Welcome to your Q&A review for the New Jersey Real Estate Salesperson exam. We'll work through real exam style questions, why each answer is right, why others are wrong, and the theory behind it. Today we cover Section 1, Property Ownership, including the bundle of rights, real property, personal property and fixtures, estates and life estates, co-ownership and liens, easements and encroachments. Our website offers free exam guides and practice questions designed to help you succeed on your New Jersey exam. All you need to do is check the link in the description below to get started right away. And remember, when it comes to studying, always study smarter, not harder, so you can reach your goals faster and with more confidence. All right, let's dive in. Question 1. A homeowner in Princeton leases out a basement apartment, grants a neighbor an easement across the driveway, and pledges the property as collateral for a mortgage while keeping the underlying ownership intact. Which of the following describes the collection of distinct ownership interests that can be separated this way? Your options are A. The bundle of rights, B. Fee simple defeasible, C. allodial title, D. The Doctrine of Ishkid. Which one is it? Pause the video if you need more time. The correct answer is A. The bundle of rights. A is correct because the bundle of rights describes ownership as a collection of separable legal interests such as possession, use, exclusion, enjoyment, and disposition. An owner may lease, mortgage, or grant easements on individual sticks while retaining the fee. B is wrong because fee simple defeasible names an estate that can end if a stated condition fails. It describes the duration and conditions attached to an ownership interest, not the divisible character of the rights an owner holds at one moment. C is wrong because allodial title refers to ownership free of any superior landlord. The American system contrasted with the feudal model. The term answers who ultimately owns the land, not what separable rights flow from that ownership. D is wrong because escheat is the government's power to take property when an owner dies without heirs or a will. That power sits on the public side of the four state powers and has nothing to do with an owner's divisible interests. Owning real estate isn't owning one solid thing. It's holding a bundle of separate legal rights, and understanding that bundle unlocks almost everything else in property law. Picture a bundle of sticks. One stick is the right to possess, another the right to use, another to exclude others, another to enjoy the property in peace, and the last is the right to dispose of it. Pull one stick out and the bundle still stands. Watch what the owner keeps, not just what she gives away. Grant a lease and she hands over possession but keeps the reversion, the right to get it back. She still holds the underlying fee the whole time. Exam writers love to test the bundle against lookalikes. Fee simple defeasible is about duration, not divisibility. Allodial title answers who ultimately owns the land free of a feudal crown. Escheat is the government reclaiming property with no heirs. A public side power with nothing to do with an owner splitting private rights. A lease, a mortgage, and an easement can all sit on one parcel at once, each handing out a different stick while the owner keeps the rest. That's the bundle of rights in action, and it's the lasting lesson to carry into every transaction. Question 2. A seller in Hoboken removes the dining room chandelier the day before closing, replaces it with a bare ceiling socket, and tells the buyer the fixture was personal property. Which of the following items is best classified as real property unless the contract states otherwise? Your options are A. Furniture sitting in the living room, B. An area rug placed over hardwood, C. A wired ceiling chandelier, D. A freestanding refrigerator. Take a second. Which answer would you pick? The correct answer is C. A wired ceiling chandelier. C is correct because a chandelier wired into the ceiling box meets the test of attachment and adaptation. It has been installed in a way that makes it part of the home. Removal damages the structure, so it passes with the real property. A is wrong because furniture sitting in the living room is unattached personal property. The seller can lift it and carry it out without altering the dwelling, which keeps it outside any reasonable definition of a fixture. B is wrong because an area rug rests on the floor without permanent attachment to the structure. It moves between homes the way any household item does, and nothing about its placement converts it into part of the realty. D is wrong because a freestanding refrigerator plugs into a standard outlet and rolls out on its own wheels. The connection is temporary by design, so the appliance stays chattel unless the bill of sale explicitly transfers it. A seller unscrews the chandelier the night before closing and claims it was hers to take. Whether she's right depends on a single legal line, the difference between real property and personal property, and that line decides what actually transfers with the deed. Real property is land and anything permanently attached to it. Personal property or chattel is anything movable and unattached. A fixture is special. It started as chattel but became real property once it was installed into the structure, which is exactly why a deed and a bill of sale cover different things. Picture the chandelier wired into the ceiling box and bolted to the framing. Loose in a box at the store it was chattel, but once it's wired and bolted in, removing it tears into the structure itself, and that damage is what proves it has become part of the house. Furniture is unattached and simply carried out. An area rug rests on the floor and moves like any household item. A freestanding refrigerator plugs into an outlet and rolls on its own wheels, so its connection is temporary by design. The wired chandelier is different in kind, not degree, because its attachment is permanent. Attachment is the first test, but not the only one. Courts also ask whether the item was adapted specifically to that property and whether the parties intended it to stay, like a custom storm window cut for one odd window. A well-drafted contract that lists what stays and what goes beats every test, because it settles the question before the dispute ever starts. Question 3. A buyer in Cherry Hill inspects a colonial home and notices a built-in bookcase bolted to the wall, custom sized to a specific alcove, and installed by the seller 5 years ago. Which test would best help a court determine whether this item is a fixture that passes with the real estate? Your options are A. The doctrine of caveat emptor, B. The rule against perpetuities, C. The 4 unities of joint tenancy, D. The Maria test. Before I reveal it, which one do you think is right? The correct answer is D. The Maria test. D is correct because Maria looks at method of attachment, adaptation, relationship of the parties, intent, and agreement. A bookcase bolted to the wall and custom fitted to an alcove satisfies attachment, adaptation, and intent, which supports treating it as a fixture. A is wrong because caveat emptor places the burden of investigation on the buyer of real estate. It speaks to disclosure of defects, not to the legal classification of an item that may have crossed the line from chattel to realty. B is wrong because the rule against perpetuities limits how long a future interest may remain contingent before vesting. It applies to estates and trusts, not to whether a built-in shelf has been so attached that it has become part of the home. C is wrong because the 4 unities of time, title, interest, and possession govern the creation of a joint tenancy. They define a form of co-ownership rather than the test used to convert personal property into real estate. When one person calls a built-in bookcase part of the house and another calls it furniture, courts need more than a gut feeling. That is why property law developed a structured checklist called MARIA. Maria stands for method of attachment, adaptation, relationship of the parties, intent and agreement. Courts weigh all 5. though intent is often treated as the most important, since the other factors are really just evidence of what the installer meant to do. Picture a bookcase bolted into a wall alcove, custom cut to fit that exact space, installed by the home seller years earlier. Method of attachment, adaptation, and intent all point the same direction, so the bookcase is almost certainly a fixture that stays with the house. Exam writers surround Maria with look-alike doctrines. Caveat emptor governs a buyer's duty to investigate defects. The rule against perpetuities limits how long a future interest can stay contingent, and the four unities define how a joint tenancy is created. None of these decide fixture status, only Maria does. Whenever a scenario mentions something attached, adapted, or built in, that is your cue to run Maria. The fixture is the conclusion, and Maria is simply the structured reasoning a court uses to get there. Question 4. A restaurant tenant in Newark installs a custom walk-in cooler, refrigerated display cases, and a bar back, all bolted to the building so the equipment can run the business. At the end of the lease, the tenant wants to remove them. Which doctrine best allows that removal? Your options are the Doctrine of Lakes, B, the trade fixture exception, C, adverse possession, D, the estoppel doctrine. What's your answer? Commit to one before I continue. The correct answer is B, the trade fixture exception. B is correct because items a commercial tenant installs to conduct business are trade fixtures and remain the tenant's personal property. The tenant may remove them before the lease ends, provided the tenant repairs any damage caused by the removal. A is wrong because Lakers bars a party who unreasonably delays asserting a right and prejudices the other side. It is an equitable defense against stale claims and has no bearing on removal of business equipment installed during a commercial lease. C is wrong because adverse possession lets a trespasser acquire title through open, continuous, hostile use over a statutory period. It deals with ownership of land taken without permission, not equipment a paying tenant installed for a commercial purpose. D is wrong because estoppel prevents a party from contradicting a prior position when another reasonably relied on it. It addresses inconsistent conduct between the parties and does not by itself permit a tenant to take back installed business equipment. Normally anything bolted to a building becomes part of the building, but for commercial tenants that rule would be a disaster, so the law carves out an exception. The whole mechanism runs on intent and purpose. A homeowner attaching something signals permanent improvement, but a commercial tenant attaching equipment signals only an intent to operate for the lease term, not to gift it to the landlord. Picture a restaurant tenant who bolts in a walk-in cooler, refrigerated display cases, and a bar back to run the kitchen and service line. At the end of the lease, that equipment is treated as the tenant's personal property, not the landlord's. The tenant may remove trade fixtures at or before the end of the lease, but must repair any damage the removal causes. Wait too long with no holdover arrangement, and the tenant can lose that right, letting the fixtures pass to the landlord instead. A homeowner's attached chandelier stays with the house, but a business tenant's attached cooler goes with the tenant. That contrast, installer and purpose, is the entire trade fixture doctrine. Question 5. A farmer in Hunterdon County plants and tends sweet corn each spring on land she rents under a 1-year lease. Mid-season she sells the farm, but the lease continues. Which doctrine best identifies the corn as the tenant's personal property she may harvest? Your options are A, the Doctrine of Emblements, B, the Doctrine of Escheat, C, the Doctrine of Lattice, D, the Doctrine of Merger. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A, the Doctrine of Emblements. A is correct because implements are annual crops produced by a tenant's labor. New Jersey treats them as the tenant's personal property and lets the tenant return to harvest after the tenancy ends, protecting the labor invested in the growing season. B is wrong because escheat is the state's power to take property of an owner who dies without heirs. It runs only on the death of an owner with no successors, which has no application to a living tenant's right to harvest planted crops. C is wrong because likas is an equitable defense against a plaintiff who waits too long to bring a claim. It is about delay in asserting rights, not about whether annual crops planted by a tenant remain that tenant's personal property. D is wrong because merger occurs when a greater estate and a lesser estate held by the same person blend into one. That doctrine governs estates and land, not the ownership of a sweet corn crop the tenant has cultivated through the season. Why does the law let a tenant come back and harvest a crop after the lease has ended? Because it ties the right to reap to the act of sowing. A tenant farmer plows, plants, waters, and weeds for an entire growing season before there's anything to harvest. If the tenancy ends the moment before the crop matures, the doctrine of implement says that labor does not simply belong to the landlord. Implements are annual crops that exist only because someone planted and tended them each year, like corn, wheat, or vegetables. The law treats these as the tenant's personal property, not part of the real estate, so they don't automatically pass with the land when the tenancy ends. Picture a farmer's sweet corn rooted in land she rents. Even after the lease ends or the land changes hands, the doctrine of implements marks that crop as her personal property, giving her the right to enter and carry it away. Exam writers like to surround implements with similar sounding doctrines. Escheat concerns an heirless owner's death. Likas concerns a claimant who waited too long. And merger concerns estates fusing together. None of them touch who owns the harvest. Question 6. A surveyor describes a parcel in rural Sussex County by reciting a point of beginning, then a series of compass bearings and distances that close back at the starting point, identifying natural and artificial monuments along the way. Which method of legal description is being used? Your options are A. Government survey method, B. Recorded plat method, C. Meets and bounds, D. Street address only. Which would you go with? Lock it in before the reveal. The correct answer is C. Meets and bounds. C is correct because meets and bounds describes a tract by directions and distances from a point of beginning, around the perimeter, and back to the same point, citing monuments. It is the oldest method and remains valid for irregular parcels. Is wrong because the government survey method divides land into townships and sections using principal meridians and baselines. New Jersey was never platted under that federal system, so the description here is not built on the rectangular grid. B is wrong because the recorded plat method references a lot and block on a filed map. The description moves around a perimeter rather than pointing to a numbered lot, so the plat method is not in use. D is wrong because a street address identifies a mailing location but is not legally sufficient to convey or precisely describe real property. Deeds require a description that locates the parcel without ambiguity, which a postal address cannot do. Meets and bounds is the oldest surviving method of describing land, and its age explains both how it works and why it still matters in New Jersey. It describes a parcel by tracing its perimeter in measured steps rather than pointing to a map or an address. A description starts at a fixed point of beginning, then recites bearings and distances that move around the edge of the parcel, citing monuments like an iron pin, a stone wall, or a large oak along the way. Closing the loop back at the starting point proves the description actually encloses land. Picture a surveyor in rural Sussex County setting a point of beginning, then walking bearing after bearing, calling a stone wall here and an iron pin there, until the final call brings the line back to the exact spot where it started. That closed traverse, anchored to monuments and returning to its origin, is meets and bounds in its purest form. When calls in a description conflict, courts give the greatest weight to natural monuments like a river or market tree, then artificial monuments like an iron pin or stone wall, then courses and distances, then area. A monument you can walk out and touch is harder to mistake than a number copied through generations of deeds. Because New Jersey was settled before the Federal Survey grid existed, meets and bounds remains its native tongue for describing irregular, centuries-old parcels. It endures because it captures land the way it really lies. Question 7. A developer in Bergen County records a subdivision map showing 100 numbered building lots, each tied to a specific block, with public streets and easements drawn in. Future deeds in the subdivision reference only the lot, block, and recorded map. Which legal description method is in use? Your options are A. Meets and bounds, B. Government rectangular survey, C. Benchmark elevation method, D. Lot and block. Don't overthink it. Which one feels right? The correct answer is D. Lot and block. D is correct because the lot and block method, also called the recorded plat method, identifies a parcel by referencing the lot and block number on a subdivision map filed with the county. It is the dominant method for residential subdivisions in New Jersey. A is wrong because meets and bounds traces a perimeter through bearings, distances, and monuments. Valid in New Jersey. It is not the method when a deed simply names a lot and block on a previously recorded subdivision map. B is wrong because the government rectangular survey overlays land with principal meridians, baselines, townships, ranges, and sections. That system organized Western public lands and was never extended over New Jersey's colonial era boundaries. SAR is wrong because benchmark elevation is a vertical reference used by surveyors to establish heights above sea level. It supports a description rather than standing alone as a method for identifying the boundaries of a building lot. Modern subdivisions run on the lot and block method, and it's easiest to understand as a two-step process rather than a bare definition. First, a surveyor lays out the subdivision and prepares a plat showing every lot, block, street, and easement to scale. Second, that plat is recorded in the county's public records. From then on, a deed can convey a parcel in a single line simply by naming its lot, its block, and the recorded map. Picture a Bergen County developer filing a map showing 100 numbered lots grouped into blocks, with streets and drainage easements drawn in. That filed plat becomes the master document every future deed points back to. The mechanism depends entirely on the recorded map. The lot's number alone carries no descriptive power. It merely points to the plat where the real detail lives. Without a properly recorded map, a bare lot and block reference describes nothing, which is why subdivision made this method necessary in the first place, replacing the impractical task of tracing hundreds of full perimeters. Whenever a scenario mentions a subdivision, a recorded map, or a filed plat with a lot and block number, that's your signal. The recorded map carries the survey detail, and the deed carries only the reference. Question 8. A buyer is looking at land in Iowa described by reference to a principal meridian, a baseline, a township number, a range number, and a section number that yield a 640-acre quadrant. Which system of legal description does this language reflect? Your options are A. Meets and bounds, B. Government rectangular survey, C. Lot and block, D. Street address recital. Got a guess? Lock it in. The correct answer is B. Government rectangular survey. B is correct because the government rectangular survey divides federal land into 6-mile square townships built of principal meridians and baselines. Each township holds 36 1-mile square sections of about 640 acres, identified by township, range, and section number. A is wrong because meets and bounds uses bearings, distances, and monuments along a parcel's perimeter back to a point of beginning. It does not appear here, since the recital identifies a section in a township grid rather than an irregular tract. C is wrong because lot and block points to a numbered lot on a subdivision map recorded with a county clerk. The question references townships, ranges, and a section grid laid down by the Federal Survey, which is a different system entirely. D is wrong because a street address pinpoints a mailing location but cannot legally describe a parcel for conveyance. The detailed survey citations to principal meridian, township, range, and section reach far beyond what any postal address could provide. The government rectangular survey wasn't just a measuring method, it was an act of national planning. Understanding its history explains how it's built and why it never touched New Jersey. The system rests on principal meridians running north and south and baselines running east and west. Their crossing point anchors townships, 6 miles on a side, which are subdivided into 36 sections, each 1 square mile, or 640 acres. Sections are numbered starting in the northeast corner and snaking back and forth. So Section 1 and Section 36 always sit in known positions. Naming a meridian, baseline, township, range, and section pinpoints 1 square mile anywhere the grid was laid down. Exam writers test the system against the methods that actually apply in New Jersey, meets and bounds, which traces bearings and monuments around an irregular perimeter, and lot and block, which points to a numbered lot on a recorded map. A street address, meanwhile, can never legally describe land. The rectangular survey was designed for open, previously undescribed western land, not for territory already carved up by colonial deeds. That's why it organized the public domain from Ohio westward, but never reached back over New Jersey's centuries-old meets and bounds. Question 9. A title company in Trenton must precisely identify a small triangular lot carved out of an older estate where the boundary jogs and follows an old stone wall. The lot is not part of any recorded subdivision. Which legal description method would best handle this parcel? Your options are A. Meets and bounds, B. Government rectangular survey, C. Lot and block, D. Street address description. Which one is it? Pause the video if you need more time. The correct answer is A. Meets and bounds. A is correct because meets and bounds handles irregular parcels and natural monuments well. It traces the boundary by bearings, distances, and references such as a stone wall, which lets the survey close on a triangle that would not fit a numbered lot. B is wrong because the government rectangular survey was not extended over New Jersey colonial holdings. Even where the system applies, it organizes land into 1 mile square sections rather than odd triangles that follow a fence line or a historic stone wall. C is wrong because lot and block requires the parcel to appear as a numbered lot on a recorded subdivision map. The tract was carved from an older estate and is not part of any subdivision, so no lot number exists to reference. D is wrong because a street address fixes a mailing location but is not legally adequate to describe land for transfer. A small triangular tract along an old stone wall needs survey precision that a postal address could never provide. The real skill isn't reciting what meets and bounds means. It's knowing which description method actually works for a given parcel, because the right choice depends entirely on the shape and history of the land. The rectangular survey assumes a grid of uniform squares and was never even extended over New Jersey, so it can't describe an odd triangular tract. Lot and block needs a recorded subdivision map with a lot number, which doesn't exist here. And a street address was never a legal description at all. Picture a triangular lot in Trenton, carved out of an older estate, its boundary jogging along an old stone wall. Meets and bounds traces this exact path, setting a point of beginning, running courses along the wall and around the jog, citing the wall and pins as monuments, and closing the triangle. Each of these clues rules out a competitor. Not subdivided eliminates lot and block. New Jersey eliminates the federal grid. And an irregular shape following a physical feature is exactly what meets and bounds was built to capture. Description methods are specialized tools, not interchangeable options, and meets and bounds is the one method that never loses the ability to describe a boundary, no matter how irregular the land actually lies. Question 10. An owner in Atlantic City lists every classic stick from the bundle when discussing what she gives up in a long-term ground lease, including possession, control, enjoyment, exclusion, and disposition. Which acronym best captures the same group of ownership rights? Your options are A. Das, B. Maria, C. Pised, D. Pat. Take a second. Which answer would you pick? The correct answer is C. Pised. C is correct because Pised stands for possession, control, enjoyment, exclusion, and disposition. The 5 core sticks in the bundle of rights. Each may be separated and conveyed, leased, or restricted independently, while the owner retains the others. A is wrong because DUS stands for demand. Utility, scarcity, and transferability, the 4 characteristics that give a property economic value. The acronym belongs to valuation theory, not the list of ownership rights an owner holds in a parcel. B is wrong because Maria stands for method of attachment, adaptation, relationship, intent, and agreement, the test used to classify a fixture. The acronym helps decide whether an item passes with the real estate, not to recite the bundle of rights. D is wrong because PEAT stands for police power, eminent domain, taxation, and escheat, the 4 powers government holds over private land. The acronym names the public side limits on ownership, not the private rights inside the bundle. The bundle of rights describes everything an owner holds, and PCID is the memory device that keeps its 5 sticks straight. Acronyms like this earn their place because the concepts are easy to understand but easy to mix up under exam pressure. PCED stands for possession, control, enjoyment, exclusion, and disposition. Each is a separable power, so an owner can lease out possession or grant an easement affecting use, and still keep the rest of the bundle. Picture an owner in Atlantic City signing a long-term ground lease and ticking off possession, control, enjoyment, exclusion, and disposition. She is listing the sticks in her own bundle. The private rights she hands over for the lease term, not describing value or government power. The exam clusters similar sounding acronyms on purpose. DUS names elements of value, Maria is the fixture test, and PEAT names government powers over land, while only PCED names the private rights an owner actually holds. Remember, PCED and the bundle of rights are the same idea at 2 levels of detail. Keeping PCED separate from DUS, Maria, and PEAT is exactly the discrimination the exam is built to test. Question 11. A licensed contractor in Edison records a claim against a single residential property for unpaid renovation work, attaching the claim specifically to that parcel rather than to all property owned by the debtor. Which classification of lien best describes what the contractor filed? Your options are A. A general involuntary lien, B. A voluntary blanket lien. C. An equitable life estate. D. A specific involuntary lien. Before I reveal it, which one do you think is right? The correct answer is D. A specific involuntary lien. D is correct because a mechanic's lien attaches only to the specific parcel improved by the work and arises by operation of law without the owner's consent. Being tied to one property and imposed without agreement makes it a specific involuntary lien. A is wrong because a general lien reaches all property the debtor owns in the county, such as a judgment lien recorded against a defendant. A mechanic's lien is narrower and binds only the parcel that the contractor's work actually improved. B is wrong because a voluntary lien is created with the owner's express agreement, the way a mortgage is granted. The owner did not sign any document granting the contractor a lien. The lien arises automatically when statutory filing requirements are met. C is wrong because a life estate is not a lien at all. It is a freehold interest that lasts for the life of a measuring person and concerns ownership duration, not the security a creditor takes for payment of money owed. Every lien in real estate can be placed on a simple 2x2 grid, and the exam tests whether you can drop a given lien into the right box. One axis asks whether a lien is specific, attaching to one parcel, or general, reaching everything a debtor owns. The other axis asks whether it's voluntary, created by the owner's signature, or involuntary, imposed by law with no consent. The classic occupant of the specific involuntary box is the mechanic's lien. A contractor who does unpaid renovation work files it against that one improved parcel, and it arises automatically once statutory filing rules are met. No signature needed. The wrong choices each fail the grid on one axis. A docketed judgment is involuntary but hits every asset, not one parcel. A voluntary blanket lien involves no signature match and spans multiple properties. And an equitable life estate isn't a lien at all, it's a freehold interest. Keep both traits in mind at once, narrow in reach, involuntary in origin. Master the two axes and every lien question becomes a matter of finding its box. Question 12. A homeowner in Toms River signs a mortgage to finance the purchase of a shore property, voluntarily pledging the property as security for repayment of the loan. The lender records the document in the county. Which classification of lien did the homeowner create? Your options are a general involuntary lien, B, a specific voluntary lien, C, a statutory tax lien, D, a judgment loan on all property. What's your answer? Commit to one before I continue. The correct answer is B, a specific voluntary lien. B is correct because a mortgage is created by the owner's signature and attaches only to the parcel pledged as collateral. The combination of borrower consent and a single targeted parcel makes the mortgage a specific voluntary lien on the secured property. A is wrong because a general involuntary lien is one the owner did not agree to, and that reaches all property in the county. The mortgage was signed willingly and ties only to the shore property pledged in the loan. C is wrong because a statutory tax lien arises automatically under law for unpaid property taxes or assessments. The homeowner did not consent to its creation, while a mortgage is the product of the borrower's voluntary written pledge to the lender. D is wrong because a judgment lien attaches to all real property of the debtor in the county once the docket is entered. Mortgages, by contrast, are voluntary and reach only the one parcel that the borrower described and pledged in the document. When a Toms River homeowner signs a mortgage to finance a shore property, that signature creates something very particular, a specific voluntary lien. Let's break down what those two words actually mean and why they matter. A lien is voluntary when the owner brings it into being by signing, an act of consent rather than an imposition. It is specific when it attaches only to the one parcel described in the document, not to everything the owner owns. Picture the signed mortgage as a direct link between the owner and one specific parcel. The lender's claim runs only to that named collateral, while everything else the borrower owns stays completely outside the pledge. Contrast this with involuntary liens. A general involuntary lien reaches all property without consent. A statutory tax lien arises automatically under law, and a judgment lien sweeps across all of a debtor's real property once entered. A mortgage matches none of these because it is signed and limited to one parcel. Watch for the cues: a pledge, a signature, collateral, and a single parcel securing a loan. Ask whether the owner consented, and whether the lien hits one property or all of them, and the mortgage will always answer signed and specific. Question 13. An owner in Camden faces multiple recorded encumbrance on the same parcel, including a property tax delinquency, a first mortgage, and a recorded judgment from a personal injury lawsuit. When the property is sold at a sheriff's sale, which lien generally takes the highest priority? Your options are: A. The municipal property tax line, B. The first mortgage, C. The recorded personal injury judgment, D. Whichever lien was recorded first. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. The municipal property tax lien. A is correct because property tax liens are super priority liens that come ahead of mortgages and most other claims, regardless of recording order. New Jersey municipalities depend on tax collections, so the statute moves these liens ahead of private creditors at distribution. B is wrong because a first mortgage holds high priority among private lenders and against later recorded interests. It nevertheless sits behind a municipal property tax lien, which by statute jumps ahead of even a properly recorded first mortgage at sale. C is wrong because a personal injury judgment becomes a general lien on the debtor's property once it is docketed. Even when recorded, it lines up behind property tax liens and behind any mortgage that was recorded before the judgment was entered. D is wrong because first to record priority is the usual rule among private liens of equal type, but it does not override the statutory super priority of property tax liens. A late tax lien still leaps to the front when the property is sold. When a property is sold at a forced sale, one creditor almost always gets paid first, no matter when it recorded. That creditor is the municipal tax lien, and the reason behind it is a deliberate policy choice, not luck or fairness. Municipalities fund schools, police, roads, and services from real estate taxes. If that revenue depended on where a private lender happened to fall in the recording line, towns could collect nothing at a sale, and public budgets would buckle. At a sheriff's sale, proceeds pay out in strict order until the money runs out. The municipal tax lien is satisfied first, then the first mortgage, then junior mortgages, then general liens like docketed judgments. A first mortgage is powerful against other private lenders, but it still yields to a municipal tax lien by force of statute. Recording order governs private liens among themselves, while the tax lien sits above that entire contest, as New Jersey's tax sale system makes clear. Priority isn't one rule. It's two layers: the tax lien on top by law, and every other claim sorted underneath by when it recorded. Question 14. A title examiner reviewing a Bergen County parcel finds two recorded mortgages, one from 2018 and one from 2022, plus a recorded mechanics lien filed in 2020. No tax liens are outstanding. Among the three private liens, which one would generally have the highest priority? Your options are: A. The 2022 mortgage, B. The 2020 mechanics lien, C. The 2018 mortgage, D. All three share equal priority. Which would you go with? Lock it in before the reveal. The correct answer is C, the 2018 mortgage. C is correct because when no super priority lien is involved, recording order controls priority among private liens. The 2018 mortgage was recorded first and therefore stands ahead of both the 2020 mechanics lien and the 2022 mortgage in the distribution of proceeds. A is wrong because the most recent signing date does not move a lien up the line. A later mortgage is junior to anything properly recorded before it. So a 2022 lender stands behind the 2018 mortgagee in any claim against the proceeds. B is wrong because a mechanics lien holds the same kind of priority as any other lien from its recording date, not a special elevated status over earlier mortgages. The 2018 mortgage was recorded earlier and outranks a mechanics claim filed 2 years later. D is wrong because private liens do not share equal priority when their recording dates differ. The race notice statute organizes them in the order they entered the public record. So the three claims line up by date rather than splitting on a single tier. Priority among ordinary liens follows a rule old enough to have a Latin name and simple enough to state in 5 words. First in time, first in right. Once super priority tax liens are set aside, the creditor who recorded earliest generally stands ahead of everyone who recorded later. The recording system solves a basic problem. How does a lender know what already burdens a property? Claims must be recorded to protect their priority, and the record is open for anyone to search. New Jersey follows a race notice approach, rewarding whoever both takes without notice and records first. Picture a Bergen County parcel, a mortgage recorded in 2018, a mechanics lien recorded in 2020, and a second mortgage recorded in 2022. With no tax liens outstanding. The 2018 mortgage recorded first and gets paid first. The mechanics lien comes next, and the 2022 mortgage stands last. A mechanics lien does not outrank an earlier mortgage just because it's a mechanics lien, and a larger later loan does not leap over a smaller, earlier one. Signing dates and loan amounts never reshuffle the order. Only the recording sequence does. Watch for scenarios listing multiple recorded liens by their recording years with no tax lien present. The earliest recorded claim always wins, because first in time, first in right, is enforced by a recording system that turns a date stamp into a rank. Question 15. A jury in Mercer County enters a money judgment against a defendant who owns 3 separate parcels in the county. After the clerk dockets the judgment, the prevailing party records nothing further. Which classification of lien now attaches to all 3 parcels? Your options are A. A specific voluntary lien on each parcel. B. A homestead exemption. So, A. Mechanics lien against 1 parcel. D. A general involuntary lien. Don't overthink it. Which one feels right? The correct answer is D, a general involuntary lien. D is correct because a docketed judgment automatically becomes a general lien against all real property the debtor owns in the county. The owner did not consent and the lien reaches every parcel rather than one, which makes it general and involuntary by definition. A is wrong because a specific voluntary lien attaches to one identified parcel after the owner signs to pledge it, like a mortgage. The docketed judgment here was imposed by court's order without any pledge and sweeps in more than a single property. B is wrong because a homestead exemption shields a portion of a debtor's primary residence from certain creditors. New Jersey does not have a homestead exemption of broad significance, and any such exemption protects equity rather than acting as a lien. C is wrong because a mechanics lien is filed by a contractor for unpaid labor or materials on one specific project. The lien from a personal injury or contract judgment is general and is not tied to construction work on a particular parcel. When a court dockets a money judgment, something powerful happens automatically. The judgment becomes a lien on every parcel of real estate the debtor owns in that county, all at once. Two traits define it. It's general because it sweeps in all the debtor's real property in the county, and it's involuntary because a court imposed it rather than the owner pledging it. The mechanism is docketing itself. Once a judgment is entered and docketed, the law automatically converts it into a lien covering all the debtor's real property in that county. No negotiation or signature required. Contrast this with specific and voluntary liens. A mortgage attaches to one parcel after the owner signs. A mechanic's lien binds one parcel improved by construction. A homestead exemption isn't a lien at all. Just a shield, and New Jersey offers no broad version of it. So remember the tell. One parcel plus a signature is a mortgage. One parcel plus construction is a mechanic's lien. But all parcels plus a court order is unmistakably a general involuntary lien. Question 16. A landlocked parcel in rural Hunterdon County has the legal right to use a paved driveway across the neighbor's land to reach the public road. The right runs with the land and transfers to any future owner of the landlocked parcel. Which of the following best identifies this interest? Your options are A. An easement in gross, B. An easement appurtenant, C. A revocable license, D. A profit à prendre. Got a guess? Lock it in. The correct answer is B. An easement appurtenant. B is correct because an easement appurtenant benefits a particular parcel called the dominant estate and burdens a neighboring parcel called the servient estate. The benefit runs with the land and passes automatically to each new owner of the dominant estate. A is wrong because an easement in gross benefits a person or company rather than a parcel, such as a utilities power line. It does not depend on owning a neighboring tract, so it cannot match a right tied to a landlocked lot. C is wrong because a license is permission to enter the land that the owner can revoke at any time. It does not run with the land or transfer to future owners, which separates it from a permanent driveway easement attached to the parcel. D is wrong because a profit à prendre lets the holder take something of value from the land, such as timber or minerals. It is about extraction rather than passage and does not describe a right to cross another's land to reach a road. A landlocked parcel with no access to a public road is nearly worthless, since its owner cannot build, sell, or even reach it. The law's solution is the easement appurtenant, a permanent right for one parcel to cross a defined part of a neighboring parcel. Every easement appurtenant involves two parcels in fixed roles, the dominant estate, which enjoys the right, and the servient estate, which bears the burden. The benefit stays attached to the dominant estate and the burden stays attached to the servient estate, both running with the land through every sale. Picture a landlocked parcel in rural Hunterdon County holding the legal right to use a paved driveway across the neighbor's land to reach the public road. That landlocked lot is the dominant estate. The neighbor's land is the servient estate, and the driveway is the easement connecting both to the road. This is the concept center of gravity. The right isn't a favor granted to a person. It's a feature fused to the land itself. Sell the landlocked parcel, and the new owner automatically drives the same driveway by the same right. No renegotiation needed. Whenever a scenario shows a landlocked parcel with a permanent right to cross a neighbor to reach the road, involving a dominant and servient estate that passes automatically to future owners, that's an easement appurtenant. Question 17. A pipeline company holds a recorded right to run a natural gas line across a series of parcels in Burlington County. The right benefits the pipeline operator personally and does not require the company to own any adjacent land. Which of the following best classifies that interest? Your options are an easement in gross, B. An easement appurtenant, C. An encroachment. D. A leasehold estate. Which one is it? Pause the video if you need more time. The correct answer is A. An easement in gross. A is correct because an easement in gross benefits a person or entity rather than a neighboring parcel of land. Commercial easements in gross, such as utility rights, are assignable and are recorded against the servient parcel, so they bind successive owners. B is wrong because an easement appurtenant requires a dominant parcel that receives the benefit and a servient parcel that bears the burden. The pipeline operator owns no adjacent land, so the benefit cannot attach the way the appurtenant form requires. C is wrong because an encroachment is an unauthorized physical intrusion onto another's property, such as a fence built over the line. The gas line operates under a recorded grant of authority, so it is permitted rather than an unauthorized trespass. D is wrong because a leasehold estate gives a tenant possession of an entire premises for a stated term. The pipeline company does not lease the surface. It holds only the right to maintain its line within a defined corridor. Not every easement needs a neighbor. That single fact separates the easement in gross from the appurtenant easement, and it explains how utilities and pipelines can cross land they don't own. An appurtenant easement pairs a burdened parcel with a benefited parcel. An easement in gross keeps the burdened parcel but replaces the benefited parcel with a benefited party. So the benefit sits with the holder, not with any neighboring land. Picture a pipeline operator holding the right to run a gas line across a series of parcels in Burlington County. The corridor crosses parcel after parcel, but notice there's no dominant estate anywhere on the other side, because the right is personal to the operator. Commercial easements in gross carry two key features. They're assignable, so a utility can transfer the right when it sells its system, and they're recorded against the servient parcels, binding successive owners of the burdened land. And always there's no dominant estate anchoring it. When a utility or pipeline holds a corridor right with no neighboring estate, that's an easement in gross. The lasting contrast is the missing dominant estate. Appurtenant needs a benefited parcel, while in gross travels with the company itself. Question 18. A homeowner in Westville discovers that her neighbor's wooden fence was built 3 feet over the surveyed boundary line, sitting on a strip of her front yard without any recorded easement or written permission. Which of the following best identifies the neighbor's situation? Your options are A. An easement by necessity. B. A profit à prendre. C. An encroachment. D. A reversionary interest. Take a second. Which answer would you pick? The correct answer is C. An encroachment. C is correct because an encroachment is an unauthorized physical intrusion of an improvement onto another's land. A fence built 3 feet across the surveyed line, without an easement or written permission, sits on the neighbor's parcel as an unwelcome trespass. A is wrong because an easement by necessity arises only when a parcel would otherwise be landlocked, and it requires prior common ownership of the parcels. A neighbor's fence stepping over the surveyed line has nothing to do with access to a public road. B is wrong because a profit à prendre lets the holder remove something of value from the land, such as timber or sand. A fence does not remove anything. It occupies space, which is encroachment territory rather than the extraction territory of a profit. D is wrong because a reversionary interest is a future interest retained by a grantor when a lesser estate has been conveyed. It speaks to the eventual return of ownership, not to the present physical placement of a fence over the surveyed boundary. A survey reveals that the neighbor's fence sits 3 feet onto her land with no easement and no permission. That's an encroachment. an unauthorized physical intrusion of an improvement from one parcel onto another. An encroachment is about physical space wrongfully taken, not permission granted or value extracted. A fence, roof overhang, driveway, or wall crossing the line without an easement or consent is a continuing trespass, one that persists as long as the structure stands. Picture the surveyed line running straight between two lots and the fence stepping right across it. That sliver of land under the fence, sitting on the wrong side of the boundary, is the encroachment zone. These distractors tempt because they're all real property concepts, but none describe a structure sitting over the line. An easement by necessity is about landlocked access. A profit apprender is an extraction, right? Like timber or sand. And a reversionary interest is about who gets ownership back later. An easement is a right to use. A license is permission to use. And an encroachment is a structure using what it was never granted. It's a live problem with a clock on it, not a harmless quirk of where a fence sits. Question 19. A resident in Morristown has openly used a beaten footpath across the back of a neighbor's lot for more than 20 years, continuously and without permission, to reach a public park. New Jersey law could allow a court to recognize this use as which type of property, right? Your options are A. An easement engrossed by deed. B. A license that becomes a lease. C. An encroachment by acceptance. D. An easement by prescription. Before I reveal it, which one do you think is right? The correct answer is D. An easement by prescription. D is correct because an easement by prescription arises when use of another's land is open, notorious, continuous, hostile, and without permission for the statutory period. New Jersey courts may then recognize the long-standing path as a permanent right-of-way. A is wrong because an easement engrossed requires a signed and recorded grant from the landowner to the holder of the benefit. The resident never received written permission, so the right cannot rest on a deed. It must rest on long-term adverse use. B is wrong because a license is permission the landowner may revoke at will, and that does not ripen into anything more. A lease requires a written agreement and exclusive possession, neither of which is present in a footpath used adversely for decades. C is wrong because an encroachment is an unauthorized physical structure crossing the line. A walking path leaves no permanent improvement, and the question asks what right the long-term user might gain rather than how to end an unauthorized structure. Easement by prescription is the access cousin of adverse possession. Instead of winning outright ownership through long, unauthorized use, a person wins only the right to keep using someone else's land in a particular way. Courts look for 4 specific elements. The use must be open and notorious, continuous for the statutory period, hostile, meaning without permission, and adverse to the owner's exclusive rights. The single most important element is the absence of permission, because permission is the doctrine's off switch. The law favors stability over disruption. An owner who sees the same crossing year after year and never objects has effectively acquiesced. The doctrine rewards productive use and punishes sleeping on one's rights, letting a well-worn habit harden into a legal right. Picture a Morristown resident who has openly walked a beaten footpath across the back of a neighbor's lot for more than 20 years, without permission, to reach a public park. That visible, continuous, unauthorized use is exactly the profile the doctrine converts into a permanent rite of passage. Remember the parallel. Adverse possession and prescription share the same adverse use and the same passage of time, but prescription only yields a right to use the land, never ownership of it. Question 20. A property owner in Princeton lets a friend keep a small sailboat on a back corner of the lot for the summer, with a spoken understanding that the owner can cancel at any time and the friend has no enforceable right to stay. Which of the following best identifies this arrangement? Your options are A. An easement appurtenant. B. A revocable license. C. A leasehold estate. D. An easement by necessity. What's your answer? Commit to one before I continue. The correct answer is B. A revocable license. B is correct because a license is personal permission to enter land for a specific purpose, revocable at will by the landowner. The friend has no enforceable right to remain, no recorded grant, and no transferable interest, which mark a license. A is wrong because an easement appurtenant runs with the land and benefits a neighbouring parcel as a permanent right. The friend's interest can be cancelled at any time and is personal rather than tied to ownership of an adjacent property. C is wrong because a leasehold estate gives the tenant exclusive possession of premises for a defined term under a written agreement. The friend has only spoken permission to keep a boat in a corner, far short of the possession required. D is wrong because an easement by necessity arises only when a parcel would otherwise be landlocked. Storing a sailboat in a back corner of a friend's lot bears no relation to access for a property with no other route to a public road. The gentlest interest in land is also one of the most heavily tested, precisely because it's so easy to mistake for something stronger. A license is personal permission to use another's land, and the owner can revoke it at will, leaving the permitted party with no ground to stand on. 3 traits mark a license. It is personal, revocable, and non-transferable. A license is never recorded, never runs with the land, and never survives the sale of the property. The reason this distinction carries so much weight is that the difference between a license and an easement is the difference between a favor and a right. Ask one question. Can the owner simply cancel it? If yes, it's a license. If not, it's an easement or another true interest. Consider a property owner in Princeton who lets a friend keep a small sailboat in a back corner of the lot for the summer, with a spoken understanding that the owner can cancel any time. The permission is personal to the friend, rests on nothing more than that spoken understanding, and cannot be sold or assigned to anyone. On the exam, the tells are spoken or informal permission, revocable at any time, personal to the user, with no recorded grant. The lasting contrast is durability. An easement is a property right the owner cannot simply take back, while a license lives entirely at the owner's pleasure. Question 21. A homeowner in Long Beach Island sits on a deeded shorefront parcel along a navigable tidal waterway. New Jersey law generally recognizes which of the following best identifies the special set of rights this owner has to the use of the water touching the property. Your options are A. Riparian or literal rights, B. Mineral rights only, C. Air rights above the water, D. Profit à prendre over the seabed. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Riparian or literal rights. A is correct because owners of land bordering navigable waters hold riparian rights along streams and literal rights along tidal seas and bays. These rights cover reasonable access to and use of the water, subject to state tidelands ownership and the public trust doctrine. B is wrong because mineral rights govern subsurface deposits like oil, gas, and coal. They concern what lies under the ground rather than the use of an adjoining body of water, so they do not capture a waterfront owner's interest. C is wrong because air rights deal with use of the space above the parcel for things like signage and aviation. They have no special application to a shorefront owner's use of the water and do not arise from a tidal bay. D is wrong because a profit à prendre lets the holder take something of value from another's land. Tidal seabeds are generally state property under the public trust doctrine, so even a shoreline owner cannot rest on a profit to extract from the seabed. Owning land that touches water raises a question ordinary parcels never face. What rights come with the water itself? The law gives waterfront owners a special set of rights, named differently depending on the kind of water involved. Riparian rights belong to land along a flowing watercourse, like a river or stream. Littoral rights belong to land along a tidal sea, bay, or large lake. Both give the shorefront owner reasonable access to and use of the adjoining water, but not ownership of the water itself. In New Jersey, this boundary is drawn by two doctrines. The public trust doctrine holds tidal waters and tidelands in trust for public uses like navigation, fishing, and recreation, while the state itself owns the tidelands below the mean high water line. Mineral rights govern subsurface deposits like oil and gas, not water use. Air rights concern the space above the parcel. A profit apprehend would let someone extract from the seabed, but tidal seabeds are state property under the public trust. Riparian rights for rivers and streams. Littoral rights for tidal seas and bays. Both real, but both bounded by the state's ownership of the tidelands and the public trust in the water. Question 22. A buyer in Cape May takes title to a single-family vacation home in fee simple absolute, the most complete estate recognized in New Jersey. Which of the following best identifies the category of estate that includes fee simple absolute? Your options are A. A leasehold estate, B. A non-freehold estate, C. A freehold estate, D. A future interest only. Which would you go with? Lock it in before the reveal. The correct answer is C. A freehold estate. C is correct because freehold estates are estates of indefinite duration held in ownership, and they include fee simple absolute, fee simple defeasible, and life estates. They contrast with leasehold estates, which are non-freehold interests with terminable possession. A is wrong because a leasehold estate gives the tenant possession for a defined or terminable term under a lease. Fee simple absolute is ownership of indefinite duration with no landlord, so it cannot be classified as a leasehold of any kind. B is wrong because non-freehold is another term for leasehold estates. Fee simple absolute is the deepest form of ownership recognized at law and cannot be both ownership and a leasehold tenant interest at the same time. D is wrong because A, future interest, is a right that vests in possession at a later time, like a remainder. Fee simple absolute is a present possessory estate of indefinite duration, so it is much more than a mere future interest. Every estate and land belongs to one of two great families, and sorting an estate into the right one is the first move on any estate question. The dividing line is duration and character of the holding. Freehold estates are estates of ownership held indefinitely with no landlord above the holder. Non-freehold or leasehold estates are possessory interests for a limited term, held by a tenant under a landlord. The freehold family has 3 members: fee simple absolute, the most complete estate with no conditions, fee simple defeasible, ownership that can end if a condition occurs, and the life estate, ownership measured by a lifetime. All 3 are freeholds because none has a built-in expiration clock the way a lease does. Picture a buyer taking title to a vacation home in Cape May in fee simple absolute, the most complete estate New Jersey recognizes. There's no landlord, no fixed end date, and no reversion waiting to return. Just present indefinite ownership. The lasting distinction is duration and ownership. Freeholds are owned for an indefinite time. Leaseholds are possessed for a term. And every estate question begins by choosing between those two families. Question 23. A married couple in Jersey City takes title to a brownstone with a deed expressly conveying ownership to them as husband and wife, with right of survivorship. One spouse signs a loan trying to use the home as collateral without the other spouse signing. Which form of co-ownership applies? Your options are A. Tenancy in common, B. Joint tenancy with survivorship, C. Ownership in severalty, D. Tenancy by the entirety. Don't overthink it. Which one feels right? The correct answer is D. Tenancy by the entirety. D is correct because tenancy by the entirety is reserved for legally married couples in New Jersey and carries a right of survivorship under NJSA 46.317 Fort. One spouse cannot unilaterally encumber or convey the property. Both spouses must sign for an effective pledge. A is wrong because tenancy in common has no survivorship right, and each owner can freely transfer or encumber an undivided share. The deed names a husband and wife with survivorship language, which signals the entirety form rather than the shares of common ownership. B is wrong because joint tenancy with survivorship is available to unmarried co-owners and allows any joint tenant to sever the interest unilaterally. The deed recites a married couple, which in New Jersey triggers the more protective entirety form. C is wrong because ownership in severalty means one person owns alone. A married couple, taking title together, cannot hold in severalty since two natural persons are on the deed, and any co-ownership must take one of the recognized concurrent forms. One spouse signs a loan against the family home, pledging it as collateral, while the other never signs anything. Under most co-ownership forms, that signature could bind at least the signer's share, but tenancy by the entirety exists precisely to stop that. Tenancy by the entirety is reserved for legally married couples, and its defining trait is that neither spouse can unilaterally encumber or convey the property. Both must sign for any pledge or transfer to be effective, and when one spouse dies, the survivor automatically owns the whole, outside probate. The law treats the married couple as one single unit, not two owners holding separate shares. Because they own the whole together, there is no separate half for one spouse to mortgage, sell, or hand to a creditor without the other. Consider a Jersey City couple who take title to a brownstone as husband and wife with right of survivorship, and then one spouse alone signs a loan pledging the home. Because the deed's recital triggers tenancy by the entirety, that loan signature does not encumber the property at all. The purpose is protecting the family home from one spouse's bad loan, guaranteed debt, or secret sale. Remember the marriage requirement joined to the mutual veto. Nothing significant happens to the property unless both spouses agree. Question 24. Two unrelated business partners in Newark take title together to a small rental property, with the deed expressly conveying to them with right of survivorship. They take title at the same time, by the same instrument, with equal undivided interests and equal right to possess. Which form did they create? Your options are A. Tenancy in common, B. Joint tenancy, C. Tenancy by the entirety, D. Cooperative ownership. Got a guess? Lock it in. The correct answer is B. Joint tenancy. B is correct because joint tenancy requires the four unities of time, title, interest, and possession plus express survivorship language. The deed meets all four unities and recites survivorship, which creates a joint tenancy that bypasses probate at a co-owner's death. A is wrong because tenancy in common is the default when the four unities are not satisfied and has no right of survivorship. The deed is explicit about survivorship and meets all four unities, which sweeps the parties past the tenancy in common default. C is wrong because tenancy by the entirety is available in New Jersey only to a legally married couple. Two unrelated business partners cannot hold in that form regardless of how the deed is worded, since the marital relationship is a threshold requirement. D is wrong because cooperative ownership is a corporate stock arrangement where the corporation holds title and shareholders receive proprietary leases. The deed in this question conveys real estate directly to the two partners and does not involve any cooperative corporation. Joint tenancy is a co-ownership form built around one powerful feature, the right of survivorship. When one joint tenant dies, that share doesn't pass to heirs or through a will, it simply evaporates, and the survivors automatically hold the whole estate outside probate. To create a valid joint tenancy, the deed must satisfy 4 unities at once: time, title, interest, and possession. Miss any one of these, and the law defaults to a tenancy in common instead. Picture one deed conveying property to 2 owners at once, carrying all 4 unities plus explicit survivorship language. That combination is what confirms the parties chose survivorship rather than stumbling into the default. Think of the 4 unities as a gatekeeper guarding a serious consequence. Survivorship cuts off heirs entirely in favor of surviving co-owners. That's why the law demands both the unities and clear survivorship wording before granting this powerful result. Any co-owners, related or not, can form a joint tenancy, and any one of them can sever it unilaterally by conveying their share. Satisfy the 4 unities, add the survivorship recital, and the surviving owners take the whole outside probate. Question 25. 3 siblings in Edison inherit a residential property through their mother's will, each receiving a 1/3 undivided interest with no survivorship language in the deed. One sibling later wants to sell her share to an outside buyer without the other's consent. Which form of co-ownership permits this? Your options are tenancy in common, B, tenancy by the entirety, C, joint tenancy with survivorship, D, ownership in severalty. Which one is it? Pause the video if you need more time. The correct answer is A, tenancy in common. A is correct because tenancy in common gives each co-owner an undivided fractional share that may be sold, transferred, willed, or encumbered independently. The deed omits survivorship language and divides ownership into equal shares, which places the property in the common form. B is wrong because tenancy by the entirety is limited to legally married couples in New Jersey. 3 siblings cannot hold property in that form, and one tenant could not freely sell her share even if they could, because entirety prohibits unilateral conveyance. C is wrong because joint tenancy requires the 4 unities plus express survivorship language. The deed names the siblings as 1/3 owners without a survivorship recital, so the conveyance fails to create a joint tenancy in the first place. D is wrong because severalty means one person owns alone. 3 co-owners holding undivided shares cannot describe their interest as severalty, which by definition is single owner ownership with no co-tenants on the title. Tenancy in common is the law's default setting for co-ownership, and its defining virtue is flexibility. Each owner holds an undivided fractional share that can be sold, given away, willed, or mortgaged independently, with no right of survivorship. Undivided is the part students most often misread. It does not mean each owner has a marked-off piece of land. It means each owner has a fractional interest in the entire property and an equal right to possess all of it. 3 siblings who each own a 1/3 interest each hold a stake in the whole house, and shares can even be unequal and still overlap across the entire parcel. Picture one house with 3 overlapping claims layered across the entire structure rather than 3 separate rooms. Each sibling's 1/3 interest spans the whole property, which is exactly why the form is called undivided. The distractors each impose a restriction the common form lacks. Tenancy by the entirety is limited to married couples and forbids unilateral conveyance. Joint tenancy requires express survivorship language that's missing from the deed. And severalty means one person owns alone, which cannot describe 3 co-owners together. The exam day signals are co-owners holding undivided fractional shares. No survivorship and a share sold or willed independently. Hold on to independence. Each common owner controls her share and death sends it to her heirs, not to the other owners. Question 26. A buyer in Hoboken purchases a unit in a residential building and receives an interest that includes fee ownership of the airspace inside her unit and an undivided share of the lobby, hallways, roof, and grounds, all governed by a master deed and bylaws. Which form of ownership best describes this? Your options are A. Cooperative ownership, B. Timeshare estate ownership, C. Condominium ownership, D. Ownership in severalty. Take a second. Which answer would you pick? The correct answer is C. Condominium ownership. C is correct because condominium ownership combines fee title to the airspace of an individual unit with an undivided interest in the common elements. New Jersey governs this form under the Condominium Act, which requires a recorded master deed and bylaws. A is wrong because cooperative ownership puts title to the entire building in a corporation. The resident owns stock and holds a proprietary lease for the unit. The buyer here takes fee title to an airspace, which separates condominium from cooperative ownership. B is wrong because a timeshare estate gives the buyer the right to occupy a unit for a recurring period each year. The question describes year-round ownership of a unit and a share of common areas, which is broader than a timeshare. D is wrong because severalty means a single person owns the entire property alone. The buyer here holds an undivided share of common areas alongside other unit owners, so the interest cannot be classified as solo severalty ownership. A condominium owner holds fee title to something surprising, a volume of airspace. Let's unpack the two ownership interests that ride together in every condominium. The unit owner holds real fee title to the airspace inside the unit, which can be sold, mortgaged, and inherited like any fee interest. Alongside it runs an undivided percentage interest in the common elements, inseparable from the unit. So selling the unit automatically carries the common share with it. Picture the unit's interior airspace as private property, while the lobby, hallways, roof, exterior walls, elevators, and grounds are common elements owned in undivided shares by all unit owners together. The form marries individual fee ownership with collective ownership of everything shared. Cooperative ownership puts title in a corporation and gives resident stock and a lease, not fee title. A timeshare grants only recurring occupancy, and ownership in severalty means one person owns the whole property alone, which can't describe sharing common areas with neighbors. The lasting distinction is title. A condominium owner holds real fee title to the unit, while a cooperative resident holds corporate stock and a lease. Question 27. A resident in a Manhattan-style cooperative in Jersey City pays for the right to occupy a specific apartment. The entire building is owned by a corporation. The resident owns shares of stock, and a proprietary lease entitles the shareholder to occupy the unit. Which form of ownership applies? Your options are A. Condominium ownership, B. Joint tenancy with survivorship, C. Timeshare estate ownership, D. Cooperative ownership. Before I reveal it, which one do you think is right? The correct answer is D. Cooperative ownership. D is correct because in a cooperative, a corporation holds title to the building. The resident buys shares of stock and receives a proprietary lease that grants occupancy of a specific unit, holding personal property rather than fee title. A is wrong because condominium ownership conveys fee title to the airspace of the unit, plus an undivided share of the common elements. The shareholder in a cooperative holds stock and a lease, not fee title, which is the central distinction. B is wrong because joint tenancy is a form of concurrent ownership among co-owners, defined by the 4 unities and survivorship. It describes how multiple parties hold an interest together, not the corporate and lease structure that defines a cooperative. C is wrong because a timeshare estate gives the owner the right to occupy a unit for a recurring period each year. The cooperative resident here has year-round occupancy through a proprietary lease, not the rotating intervals of a vacation timeshare. Let's break down what makes a cooperative genuinely different from every other form of ownership we've discussed. In a cooperative, a single corporation owns the entire building, land included. The resident doesn't get a deed. Instead, they buy shares of stock and receive a proprietary lease, a long-term lease that grants the right to occupy a specific apartment. That stock and lease are personal property, not real property. Because the corporation owns the whole building, it carries one blanket mortgage and pays the property taxes, which shareholders cover through monthly maintenance. And because a buyer is acquiring stock rather than land, the co-op board usually has power to approve or reject incoming buyers. Condominium ownership conveys fee title to the unit and common elements. Joint tenancy describes co-owners sharing one interest through the 4 unities. A timeshare gives only recurring seasonal occupancy. The cooperative alone trades fee ownership for stock and a lease. Whenever a scenario describes a corporation owning the building, shares of stock, and a proprietary lease granting occupancy, that's cooperative ownership. It cites personal property standing in for fee title. Question 28. A vacation property in Cape May is divided so that 26 unrelated families each hold the right to use a specific unit for 2 consecutive weeks every year, with their interest recorded as deeded fee interest in the property. Which form of ownership best describes this arrangement? Your options are A. Condominium fee ownership, B. Timeshare estate ownership, C. Cooperative stock ownership, D. A life estate pure autre vie. What's your answer? Commit to one before I continue. The correct answer is B. Timeshare estate ownership. B is correct because a timeshare estate gives each owner a recorded fee interest in a unit for a recurring period each year. New Jersey regulates these arrangements under the Real Estate Timeshare Act, which requires registration of the offering. A is wrong because condominium fee ownership grants year-round fee title to a unit's airspace and an undivided share of the common elements. The owners share use of a single unit across the calendar, which is the hallmark of a timeshare. C is wrong because cooperative stock ownership gives the buyer shares in the corporation that owns the building plus a proprietary lease for one apartment. The arrangement here vests recorded deeded fee interest in the families, not corporate stock. D is wrong because a life estate per autre vie lasts for the life of a measuring person who is not the holder. The arrangement repeats annually for 26 unrelated families and depends on no one's lifespan, ruling out any life estate. A timeshare takes one vacation unit and divides it not by floor plan, but by calendar. Each owner holds a real, recorded fee interest, but that interest only grants occupancy during a recurring period each year, like a fixed 2-week slot. Picture a Cape May condo where 26 unrelated families each own a deeded interest, but only for their own 2 consecutive weeks every year. The rights switch on for their turn and switch off the rest of the year, when other owners take possession. The defining trait is a genuine, deeded, recorded, and inheritable ownership interest that is nonetheless rationed by the calendar rather than held year-round. This periodic structure is exactly why states like New Jersey require registration and offer consumer protections against aggressive marketing. Visualize a single unit surrounded by a calendar where each slice of the year belongs to a different deeded owner. This is the axis of division that sets timeshares apart. One unit split by time, not one building split into separate units. A condominium divides a building into units by space. A timeshare divides a single unit by time, shared among many recorded owners across the calendar. Question 29. An elderly widow in Trenton signs a deed transferring her home to her son, but reserves the right to occupy and use the home for the rest of her life. Upon her death, the son will hold full fee simple title. Which interest did the mother keep for herself in this conveyance? Your options are a life estate, B, a fee simple defeasible, C, a leasehold estate, D, an estate at will. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A, a life estate. A is correct because a life estate lasts for the life of the holder, with possession and use during that lifetime. The mother kept a life estate and the son holds a remainder that ripens into fee simple at her death. B is wrong because fee simple defeasible is an ownership interest that ends if a stated condition fails. The mother did not condition ownership on an event. She limited her own interest by her own lifespan, which signals a life estate. C is wrong because a leasehold estate gives a tenant possession for a defined or terminable term under a lease, with a landlord at the other side. The mother is not a tenant of her son. She retained an ownership interest in her life. D is wrong because an estate at will gives a tenant the right to occupy for as long as both parties agree, ending whenever either chooses. The mother's interest is stronger since neither she nor the son can end her possession early. A life estate is a freehold interest that lasts only for the duration of a person's life. The life tenant fully owns and uses the property during that lifetime, and the interest ends automatically at death. Every life estate splits ownership into two fitted pieces. The present interest is the life estate itself, held by the life tenant. The future interest goes to a third party as a remainder, or back to the grantor as a reversion. The life tenant may possess, use, and enjoy the property and collect its rents, but cannot commit waste that damages or exhausts it for the remainder man. This balance gives present enjoyment to the life tenant while protecting the future owner. Picture the widow living in her Trenton home for the rest of her life, while her son waits as the remainder man. The moment she dies, the life estate ends and full fee simple ownership passes to him automatically, with nothing left to negotiate. The exam tells are simple: an interest measured by a lifetime, a reserved right to occupy, and a remainder or reversion waiting behind it. A life estate always ends at a death, never on a condition or a fixed term. Question 30. A grantor in Princeton conveys a farm to a niece for the lifetime of a third person, the grantor's elderly aunt. The niece may use the farm only as long as the aunt is living, after which the property passes back to the grantor. Which interest does the niece hold? Your options are a life estate by her own life, B, fee simple subject to conditions subsequent, C, a life estate pour de vie, D, a leasehold for years. Which would you go with? Lock it in before the reveal. The correct answer is C, a life estate pour autre vie. C is correct because a life estate pour autre vie is measured by the life of someone other than the holder. The niece holds her interest only while the grantor's aunt lives. Upon the aunt's death, ownership reverts to the grantor. A is wrong because a life estate measured by the holder's own life ends only when the holder dies. The niece's interest ends instead at the aunt's death, which is the defining feature of a pour autre vie estate. B is wrong because fee simple subject to conditions subsequent is full ownership. that can be cut short if the grantor re-enters upon a stated breach. The lease's interest is limited by a measuring person's lifespan, not by breach of any recorded condition. D is wrong because a leasehold for years is possession for a stated period under a lease, with a landlord-tenant relationship. The lease received an ownership interest in real property tied to a person's lifespan, which is freehold rather than non-freehold. Most life estates end when the holder dies, but the law also permits a subtler version measured by someone else's life entirely. That variation, the life estate pure autre vie, French for the life of another, is a favorite exam trap precisely because the measuring life and the holder come apart. The mechanism turns on separating two roles an ordinary life estate keeps together. In a standard life estate, the holder and the measuring life are the same person. In a pure autre vie estate, the holder is one person and the measuring life is another, so the estate ends when the measuring person dies, even if the holder outlives them. Picture a grantor in Princeton who conveys a farm to a niece for the lifetime of a third person, the grantor's elderly aunt. The niece may use the farm only as long as the aunt lives, and when the aunt dies, the property reverts to the grantor, whether or not the niece is still living. If the holder dies first while the measuring life continues, the estate does not simply disappear. It passes to the holder's heirs and lasts until the measuring life finally ends, because the estate's clock is set to a life that is not the owner's own. The distinction that endures is whose death ends the estate. An ordinary life estate ends at the holder's death, while a pure autre vie estate ends at the measuring person's death, with the holder's heirs taken any time left in between. Question 31. An instructor preparing students for the New Jersey salesperson exam reviews the 4 government powers that limit private ownership, captured by the mnemonic PETE. Which of the following is the correct expansion of PETE in the order it represents the 4 powers? Your options are A. Possession, eminent domain, taxation, enjoyment. B. Police power, easement, title, escheat. C. Police power, enjoyment, title, eviction. D. Police, eminent domain, taxation, escheat. Don't overthink it. Which one feels right? The correct answer is D. Police, eminent domain, taxation, escheat. D is correct because PETE stands for police power, eminent domain, taxation, and escheat. These are the 4 constitutional powers government exercises over privately owned real property, and the salesperson exam routinely tests recognition of each by description and by name. A is wrong because possession and enjoyment are sticks in the private owner's bundle of rights, not government powers. 2 of the letters mislabel private interests as state powers, which fails the basic test of the PETE mnemonic. B is wrong because easement and title are private interests rather than powers held by government. PETE refers to the public side limits on ownership. So listing easement and title for those powers misidentifies what the acronym tracks. C is wrong because enjoyment, title, and eviction are not government powers in the PTE framework. The acronym names broad constitutional authorities, and 3 of these letters point to ordinary aspects of private ownership or possession. Every private owner holds a bundle of rights, but that bundle sits underneath 4 superior government powers. The mnemonic PETE names them all, marking the outer limits of private ownership where public interest overrides an owner's wishes. Police power regulates land use for health, safety, and welfare, like zoning and building codes. Eminent domain takes property for public use with just compensation. Taxation levies assessments to raise revenue. Escheat transfers ownership to the state when someone dies with no will and no heirs. Picture the private bundle of rights, possession, use, and disposition fenced in by these 4 public powers. A town can regulate use through police power, take land through eminent domain, tax it yearly, and claim it through escheat, none of it requiring the owner's consent. The exam tests Pete by description, not by name, so watch for signal words. Regulate and protect the public welfare signals police power. Take and just compensation signals eminent domain. Assess and levy signals taxation. And no will. No here signals a sheet. Watch out for wrong answers that mislabel private interests like possession or easements as government powers. Master these 4 triggers and every Pete question becomes simple sorting. Question 32. A municipality in Hudson County plans to take a small strip of private property along a public road in order to widen the road for safer travel, paying the owner just compensation following appraisal and a public hearing. Which government power is the municipality exercising? Your options are A. Police power, B. Eminent domain, C. Issue, D. Taxation. Got a guess? Lock it in. The correct answer is B. Eminent domain. B is correct because eminent domain is the power to take private property for public use upon payment of just compensation, exercised here through condemnation for a road widening. The Fifth Amendment and the New Jersey Constitution require the compensation step. A is wrong because police power regulates private property to protect the public health, safety, morals, and general welfare through measures like zoning and building codes. It does not involve government acquiring title to land, which is the distinguishing feature of eminent domain. C is wrong because escheat transfers property to the state when an owner dies without heirs or a will. It is a default mechanism for ownerless property, not an affirmative taking of an active owner's land for a public project, like a road widening. D is wrong because taxation raises revenue through real property assessments and other levies. The municipality here is acquiring physical land for a public project rather than collecting money, which moves the exercise from taxation into eminent domain. When a government takes private land for a public project and pays the owner for it, that's eminent domain in action. Every valid exercise of eminent domain needs 2 things together. The taking must serve a public use, and the owner must receive just compensation. This pairing comes straight from the Fifth Amendment's takings clause, reinforced by the New Jersey Constitution. So payment isn't a courtesy, it's a legal requirement. This formal legal path is called condemnation. The government identifies the property, appraises it, makes an offer, and if the owner disagrees, a court steps in to oversee the taking and set fair compensation. This is what separates eminent domain from every other government power. Police power regulates land but leaves title untouched and pays nothing. Taxation collects money without acquiring the parcel. Escheat transfers title only when an owner dies without heirs, and pays nothing because there's no one left to pay. Eminent domain alone takes an active owner's land and must pay for it. Just compensation is the constitutional bargain. Government can seize the land the public needs, but it can't dump that burden on one owner alone. When you see land taken for a public project with payment made, that's eminent domain. Question 33. A property owner in Newark complains that the state's new transit project so dramatically blocks all access to her storefront that the property is now nearly worthless, yet the state never formally condemned the parcel. Which of the following remedies best describes the legal action she may pursue? Your options are A. An inverse condemnation action, B. An action for escheat reversal, C. A federal tax abatement, D. A specific performance suit. Which one is it? Pause the video if you need more time. The correct answer is A. An inverse condemnation action. A is correct because inverse condemnation is the lawsuit a private owner brings when government action effectively takes property without formal condemnation. The owner argues the government should pay just compensation because regulation or physical impact has destroyed the practical use of the parcel. B is wrong because escheat reversal is not a recognized cause of action. Escheat is the original transfer to the state when an owner dies without heirs. The storefront owner is alive and still holds title, so escheat has no role in the situation. C is wrong because a federal tax abatement reduces a federal tax burden and is not a mechanism for recovering compensation from a state transit project. The owner's claim is about a state-imposed loss of property value, not federal taxes owed. D is wrong because specific performance is an equitable remedy compelling a party to perform a contract. There is no contract at issue here, only an alleged taking by government action that calls for a constitutional rather than contractual remedy. Inverse condemnation is eminent domain run backwards. The government never files anything and never admits a taking, yet its action so damages a property that the owner must sue to force payment. In ordinary condemnation, government initiates the process and pays. In inverse condemnation, the owner starts the case instead, suing for the compensation a formal taking would have required, which is exactly why the doctrine is called inverse. Courts draw a line between a real compensable taking and mere regulation or incidental harm. A permanent physical invasion or near total destruction of use crosses that line, while traffic changes, temporary construction hassle, and ordinary regulation generally do not. Picture an owner in Newark whose storefront loses nearly all its value because a state transit project blocks all access. Though the state never formally condemned the parcel, she still holds title and was never paid $1, yet the practical use of her property is destroyed. The lasting point is who moves first. In eminent domain, government comes to the owner. In inverse condemnation, the owner must go to government. Look for a serious government-caused loss of use with no formal taking and no offer of compensation. Question 34. A New Jersey municipality enacts a noise ordinance limiting outdoor live music to specific hours, citing protection of public health and quality of life. The ordinance does not transfer any property and does not require the town to pay landowners. Which government power supports the ordinance? Your options are A. Eminent domain, B. Escheat, C. Police power, D. Taxation. Take a second. Which answer would you pick? The correct answer is C. Police power. C is correct because police power lets state and local government regulate the use of private property to protect public health, safety, morals, and general welfare. Noise restrictions enacted to safeguard quality of life and rest fall squarely within that regulatory authority. A is wrong because eminent domain physically takes property for public use and requires just compensation. The noise ordinance regulates how property may be used but does not transfer any parcel to the municipality, which keeps it outside the eminent domain power. B is wrong because escheat moves property to the state when an owner dies without heirs. It is triggered by death and intestacy with no successors, not by an ordinance regulating outdoor activity, so it has no role in justifying noise rules. D is wrong because taxation raises revenue through assessments on property and other levies. The noise ordinance neither levies a tax nor collects a fee. It regulates conduct on private property, which makes police power the proper source of authority. To tell government powers apart, ask one question: did title move or was use merely regulated? That single question unlocks nearly every property law scenario you'll face. A noise ordinance limiting outdoor music hours is a textbook example of police power. No parcel transfers, no compensation is owed, and the owner keeps full title while simply facing a rule about how the property may be used. Eminent domain takes property and therefore must pay. Police power merely regulates use and reasonable regulation is treated as a cost of living in an ordered society, not a taking that triggers payment. Police power is the busiest of the four government powers. It underlies zoning ordinances, building and housing codes, health and safety regulations, and rent controls. So recognize it first whenever you see regulation rather than acquisition. A regulation just needs a real link to a legitimate public purpose, and it cannot destroy all economic use. Short of that extreme, valid regulation under police power requires no compensation at all. Question 35. An elderly owner in Newark dies leaving no will, no spouse, no children, and no traceable heirs after diligent search by the surrogate. The county clerk records the property in the name of the state under a long-standing rule. Which government power is being applied? Your options are A. Police power, B. Eminent domain, C. Taxation, D. Eschat. Before I reveal it, which one do you think is right? The correct answer is D. Eschat. D is correct because eschat transfers real property to the state when an owner dies intestate with no heirs that can be located. New Jersey law moves ownerless property to the state rather than leaving it untitled, preserving it in the public domain. A is wrong because police power regulates the use of private property through measures like zoning and building codes. It does not move title to the state and has no role in the disposition of property when an owner leaves no will or heirs. B is wrong because eminent domain takes property for public use upon payment of just compensation. The deceased owner has no heirs to compensate, and the state is not acquiring property for a specific public project, which moves the matter out of eminent domain. C is wrong because taxation collects revenue through assessments and levies. It does not transfer title to the state on the death of an owner. That transfer is a function of the easement doctrine when no heirs or will direct otherwise. Land must always have an owner, and easement is the doctrine that guarantees it never falls into a legal void. Rooted in feudal law, where land reverted to the lord when a tenant died heirless, the modern version simply puts the state in the lord's place. Easement only activates when three narrow conditions all hold. The owner must have died. There must be no valid will, and a diligent search, often by the county surrogate, must turn up no ascertainable heirs. Fail any one condition and easement never triggers. Picture an elderly owner in Newark who dies with no will, no spouse, no children, and no traceable heirs even after a diligent search. The property cannot sit ownerless, so the county records it in the state's name under easement. Easement is not a taking. Eminent domain seizes property from a living, unwilling owner and must pay compensation, while easement receives property with no owner and no heir, so there's no one to compensate. Police power only regulates use and taxation only collects revenue. Neither one transfers title on death. The signal is always the same: a death, no will, and no fundable heirs. A easement exists so the law never tolerates a parcel with no owner at all. Question 36. A town council in Bergen County enacts a comprehensive ordinance that divides the municipality into zones for residential, commercial, and industrial use, sets minimum lot sizes and setback rules, and establishes maximum building heights. Which power of government best authorizes such an ordinance? Your options are A. Eminent domain, B. Police power, C. Taxation, D. Easement. What's your answer? Commit to one before I continue. The correct answer is B. Police power. B is correct because zoning ordinances rest on the police power, which lets local government regulate land use to protect public health, safety, and welfare. New Jersey delegates this authority to municipalities through the Municipal Land Use Law. y a NJSA. 4552 in ESUC. A is wrong because eminent domain is the power to take title to private property for public use upon paying just compensation. Zoning regulates how owners use their land but does not transfer title to the municipality, which separates regulation from condemnation. C is wrong because taxation is the power to raise revenue through assessments and levies. Zoning ordinances govern how property may be used rather than collect money, so taxation does not provide the constitutional basis for districting. D is wrong because escheat moves property to the state when an owner dies without heirs. It has no role in the enactment of land use districts and lot dimension standards, which arise from the regulatory police power instead. Zoning is the largest and most familiar use of the police power, and understanding that root is the key to every land use question on the exam. The distinction the exam presses is regulation versus acquisition. Zoning restricts and channels land use while owners keep full title, unlike eminent domain, taxation, or escheat, none of which fit an ordinance that simply tells owners what may be built where. A comprehensive ordinance divides a town into residential, commercial, and industrial districts, each with its own lot size, setback, and height rules, regulating use while leaving ownership untouched. Because zoning is police power, it requires no compensation, must reasonably advance public health, safety, and welfare, and can reach only as far as the state's enabling statute, New Jersey's Municipal Land Use Law, allows. Every zoning question comes back to this. Municipalities regulate land use under police power delegated by the state through the Municipal Land Use Law, not through eminent domain, taxation, or escheat. Question 37. A planning consultant in Princeton explains to a class that the municipality's master plan is the long-range policy document that guides land use, while the zoning ordinance translates that vision into binding rules. Which of the following best states the legal relationship between the two? Your options are A. Zoning must conform to the master plan. B. The master plan binds owners as law. C. Zoning eliminates the need for a plan. D. The zoning board enacts the master plan. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. Zoning must conform to the master plan. A is correct because under the Municipal Land Use Law, the master plan is the policy framework, and the zoning ordinance is the enforceable regulation that must generally conform to the plan. The planning board prepares the plan. The governing body adopts zoning. B is wrong because the master plan is a planning document and policy guide, not a code that imposes binding rules on landowners. Enforcement requires adoption of a zoning ordinance, which is the instrument that actually regulates uses, setbacks, and heights. C is wrong because the Municipal Land Use Law requires a master plan as the planning foundation for zoning. The plan does not become unnecessary once zoning is adopted. It remains the guiding document the zoning regulations are supposed to implement. D is wrong because the Zoning Board of Adjustment hears variance and appeal matters. It does not adopt the master plan. The planning board prepares the master plan, and the governing body adopts the zoning ordinance, which keeps the roles separated. Two documents govern land use in a New Jersey municipality, and confusing them is one of the most common exam traps. Let's pin down exactly how they relate. The master plan is the long-range policy document setting the community's vision for land use. The zoning ordinance is the enforceable law translating that vision into binding rules on setbacks, heights, uses, and lot sizes. The relationship runs one way. Zoning must conform to the master plan. Getting the players right is half the battle. The planning board studies the community and drafts the master plan. The governing body, the elected council, adopts the zoning ordinance that gives the plan legal teeth. And the Zoning Board of Adjustment is a separate body entirely, hearing variances and appeals. The master plan comes first in logic and in law, but it is not itself a code that binds owners. No one can be cited for violating it. The zoning ordinance is where policy becomes law, expected under the municipal land use law to be substantially consistent with that plan. The law separates policy from regulation to force deliberate planning before binding rules take effect, giving owners and courts a yardstick against arbitrary zoning. Policy guides law, and that direction of conformity is fixed, never reversed. Question 38. A homeowner in Cherry Hill seeks permission to build a porch that would extend 2 feet into the required front yard setback because the lot is unusually shallow and the strict application of the zoning rule causes undue hardship. Which type of relief is the homeowner seeking? Your options are A use variance, B, a conditional use permit, C, a hardship bulk variance, D, a site plan amendment. Which would you go with? Lock it in before the reveal. The correct answer is C, a hardship bulk variance. C is correct because a hardship or C1 variance, sometimes called a bulk variance, addresses dimensional restrictions like setbacks and lot coverage when strict enforcement creates undue hardship due to peculiarities of the parcel. The Zoning Board of Adjustment hears the application. A is wrong because a use variance, also called a D variance, permits a use not allowed in the zone, such as a small commercial use in a residential district. The request here is to bend a setback rule, not to permit a forbidden use. B is wrong because a conditional use permit allows a use specifically listed in the zoning ordinance as permitted with conditions. The homeowner is not asking for a listed conditional use. He is asking to extend a porch beyond the dimensional setback. D is wrong because a site plan amendment refers to changes in a site plan already under planning board review. The porch question is about an individual residential setback issue handled at the Zoning Board of Adjustment, not a site plan amendment process. Zoning rules are rigid, but real parcels are irregular. So every zoning system needs a safety valve called the variance, a permission to depart from the ordinance when strict compliance causes undue hardship. A bulk variance, also called a dimensional or hardship variance, and known in New Jersey as a C variance, deals only with physical measurements like setbacks, lot coverage, lot area, and building height. Picture a Cherry Hill homeowner whose lot is unusually shallow, so a porch would extend 2 feet into the required front yard setback. A hardship rooted in the land itself, not in personal preference. The board grants a bulk variance only when a peculiar physical condition of the parcel creates the hardship, and only if relief causes no substantial detriment to the public good or the zoning plan's intent. That is the hallmark of the bulk variance. The use itself is never in question, only a measurement, which is exactly what separates it from its far more demanding cousin, the use variance. Question 39. A property owner in Trenton wants to operate a small coffee shop on a parcel located in a strict residential zone where retail business is not a permitted use. Which type of relief, granted only on stringent statutory proof, would be required for the coffee shop to operate? Your options are A AC1 hardship variance, B AC2 flexible variance, C a site plan waiver, D AD variance for use. Don't overthink it. Which one feels right? The correct answer is D, a D variance for use. D is correct because a D variance, also called a use variance, allows a use not permitted in the zone and requires proof of special reasons and that the relief comes without substantial detriment to the public good. The board decides by supermajority. A is wrong because a C1 hardship variance addresses dimensional rules like setbacks, lot area, and lot coverage when strict application causes hardship. It does not authorize a use the ordinance prohibits, which is the issue with a coffee shop in a residential zone. B is wrong because a C2 flexible variance allows dimensional relief that advances the purposes of the MLUL when the benefits substantially outweigh detriments. It still concerns bulk standards, not the conversion of a residential parcel into a retail business use. C is wrong because a site plan waiver is a procedural step that excuses formal site plan review for minor projects. It does not authorize an unpermitted use. So a coffee shop in a strict residential zone would still need the underlying use variance. The use variance is the bulk variance's more demanding cousin, and the gap between them is deliberate. A bulk variance bends a dimensional rule for a use the zone already allows. A use variance called a D variance in New Jersey authorizes a use the ordinance forbids entirely. The heightened burden shows up in both proof and vote. An applicant must show special reasons, prove no substantial detriment to the public good, and show no substantial impairment of the ordinance's intent. Beyond that, the zoning board must approve by a supermajority, not a simple majority. Consider a property owner in Trenton who wants to run a small coffee shop in a strict residential zone where retail isn't permitted at all. This isn't bending a measurement, it's introducing a forbidden commercial use into a residential district, and only a D variance, decided by supermajority, can authorize it. A C1 hardship variance only addresses dimensional rules like setbacks, not a prohibited use. A C2 flexible variance also concerns bulk standards and still can't convert a residential parcel to retail. A site plan waiver merely excuses formal review and authorizes no unpermitted use at all. Bulk variances answer how big, how tall, how close to the line for use is already allowed. Use variances answer the weightier question of what kind of use may exist at all. When a scenario places a forbidden use into a district, the answer is always a use variance. Question 40. A small auto repair shop in Toms River has operated lawfully since the 1970s, but the surrounding area was rezoned strictly residential in 2010. The shop continues operating without expanding, structurally changing, or interrupting use. Which of the following best describes the shop's legal status? Your options are A. An illegal use that must close now. B. A legal non-conforming use subject to limits. C. A conditional use entitled to expand. D. A protected accessory structure use. Got a guess? Lock it in. The correct answer is B. A legal non-conforming use subject to limits. B is correct because a non-conforming use that lawfully existed before a zoning change may generally continue under New Jersey law, but it cannot be expanded, structurally altered, or rebuilt after destruction or abandonment without zoning relief. The shop remains a lawful non-conforming use. A is wrong because an established use that was lawful when it began is not made illegal by a later rezoning. The protection that attaches to non-conforming uses prevents the immediate closure of an existing operation, although it does not allow open-ended expansion. C is wrong because a conditional use is a use specifically listed in the ordinance as permitted with stated conditions. The auto repair shop is not a listed conditional sole use in a strictly residential zone. It survives only because it predated the rezoning. D is wrong because an accessory structure is a smaller building such as a shed or garage incidental to a principal use. The auto repair shop is itself the principal use and is not protected as an accessory. Its protection comes from non-conforming use doctrine. When zoning laws change, what happens to a business that was perfectly legal the day before? This is the story of the legal non-conforming use, also called a grandfathered use. The core idea is fairness. If a use was lawful when it started, the law lets it continue even after the zoning rules shift around it, because shutting down an established business overnight would be unjust. That protection comes with strict boundaries. The use cannot be expanded, cannot be structurally altered, cannot be swapped for a different non-conforming use, and the right disappears if the use is abandoned or the building is destroyed. Picture the shop sitting inside the new residential boundary. It's allowed to keep operating exactly as it is, but any expansion beyond its current footprint is blocked by the new zoning line around it. The doctrine protects the owner's existing investment, not future growth. It bars the right to keep operating as is, while time and attrition are expected to phase the mismatch out. Question 41. A school district in Bergen County wants to build a new elementary school on a parcel zoned for residential use, in a zone where the ordinance specifically lists schools as a permitted conditional use upon meeting stated standards. Which approval best allows the project to proceed? Your options are A conditional use approval, B, a D variance from the zoning board, C, an eminent domain proceeding, D, a site plan waiver from the council. Which one is it? Pause the video if you need more time. The correct answer is A, a conditional use approval. A is correct because when the ordinance lists a use as conditional, the planning board reviews the application for compliance with the conditions in the ordinance and the standards in the MLUL. A school listed conditionally needs only conditional use approval. B is wrong because AD variance is required only when the ordinance prohibits a use altogether. The school is already listed as a conditional use in the residential zone, which means the proper path is conditional approval rather than a use variance. C is wrong because an eminent domain proceeding is the means by which government takes private property for public use. The district can pursue a school approval directly because the use is permitted conditionally, and no taking is required to make the project lawful. D is wrong because a site plan waiver excuses formal site plan review for minor projects, but does not authorize any particular use. The school project still needs conditional use approval, which the planning board grants when statutory standards are met. Zoning sorts every use into one of three categories: permitted as of right, prohibited outright, or permitted conditionally. Knowing which category a use falls into tells an owner exactly which approval path to take. A conditional use sits in the middle. The ordinance affirmatively lists it as allowed in the zone, but only if the project meets specific standards. Schools, houses of worship, and hospitals are commonly made conditional in residential zones, welcome in principle, but subject to conditions managing size and impact. The approval for a conditional use is granted by the planning board, not the zoning board of adjustment, because the ordinance already decided the use belongs in the zone once conditions are met. No variance is needed. The applicant only proves compliance with standards addressing lot size, buffering, parking, and access. The pivotal distinction the exam presses hardest is conditional use versus use variance. A conditional use is listed with conditions and goes to the planning board. A use variance is needed only when the ordinance forbids the use entirely, requiring stringent proof and a supermajority before the zoning board of adjustment. If the ordinance names the use as conditionally allowed, the owner simply proves compliance and needs no variance. That listing is what separates a conditional use from a forbidden use that only a variance can rescue. Question 42. The New Jersey Supreme Court held that every municipality must provide a realistic opportunity for its fair share of regional low and moderate income housing. Which of the following best identifies the line of decisions establishing that constitutional obligation? Your options are A. The Pinelands cases, B. The Strawn v. Canuso line, C. The Mount Laurel Doctrine, D. The Marini or Ireland line. Take a second. Which answer would you pick? The correct answer is C. The Mount Laurel Doctrine. C is correct because the Mount Laurel Doctrine, beginning with Mount Laurel 1 in 1975 and extending through Mount Laurel 2 and the 2015 Mount Laurel III decision, requires each municipality to provide a realistic opportunity for its fair share of regional affordable housing. A is wrong because the Pinelands cases concern development controls within the federally and state protected Pinelands area. They focus on environmental preservation under the Pinelands Protection Act, not on a municipality's obligation to plan for affordable housing. B is wrong because the Strawn v. Canuso line addresses a builder's and broker's duty to disclose off-site conditions to buyers of new homes. It is part of the disclosure regime and has nothing to do with a municipality's affordable housing obligations. D is wrong because the Marini v. Ireland line established the tenant's right to repair and deduct when the landlord breaches the implied warranty of habitability. It addresses landlord-tenant law rather than constitutional affordable housing obligations. Few doctrines are as distinctly New Jersey as this one. The constitutional command that every town must open the door to affordable housing. The New Jersey Supreme Court held that every municipality has a duty to provide a realistic opportunity for its fair share of regional low and moderate income housing. The doctrine grew from exclusionary zoning, where towns used large minimum lot sizes and bans on multifamily housing to price out lower income families. Because zoning power comes from the state and must serve the general welfare, the court reasoned a town cannot use it to exclude the poor and dump the housing burden on its neighbors. The doctrine developed across 3 decisions. The first in 1975 established the fair share obligation. A second decision introduced the builder's remedy, and a third, in 2015, restored the courts to reviewing compliance after the administrative process stalled. Named for Mount Laurel Township in Burlington County, the doctrine's most powerful tool is the builder's remedy. A developer who proves a town's zoning is exclusionary and who agrees to include affordable units can win court permission to build even over local objection, turning developers into enforcers of a constitutional duty. Distractors name real but unrelated law. The Pinelands cases govern environmental controls. The disclosure line covers off-site conditions, and repair and deduct belongs to landlord-tenant law. None of these touch a town's constitutional duty to plan for its fair share of housing. Question 43. After the 2015 New Jersey Supreme Court decision in Mount Laurel III, jurisdiction over municipal affordable housing compliance shifted from a state administrative agency back to the courts, because that agency had effectively stopped issuing binding round rules. Which agency had previously held that primary administrative role? Your options are A. The Department of Banking and Insurance, B. The Pinelands Commission, C. The Department of Environmental Protection, D. The Council on Affordable Housing. Before I reveal it, which one do you think is right? The correct answer is D. The Council on Affordable Housing. D is correct because the Council on Affordable Housing, known as CO, was created to administer Mount Laurel compliance through fair share rules and certifications. After COA failed to adopt third-round rules, the 2015 decision returned primary review to the trial courts. A is wrong because the Department of Banking and Insurance oversees the New Jersey Real Estate Commission and the Appraiser Board. It does not administer affordable housing obligations. which were entrusted to COA and now flow through the courts after the 2015 decision. B is wrong because the Pinelands Commission regulates development within the Pinelands area under the Pinelands Protection Act. It has no jurisdiction over a municipality's fair share affordable housing obligation outside its boundaries, which is a separate constitutional doctrine. C is wrong because the Department of Environmental Protection administers environmental statutes such as the Wetlands Act and the Spill Act. It does not certify fair share housing plans, a role originally assigned to COA under the Fair Housing Act of 1985. A constitutional duty needs machinery to enforce it, and for decades that machinery was the Council on Affordable Housing, or COA. COA was built to move affordable housing compliance out of scattered court battles and into a uniform administrative process. It would calculate fair share numbers, set rules, and certify towns, and a certified town earned protection from builders' remedy lawsuits. A town would follow COA's fair share rules, submit a housing plan, and receive substantive certification, which acted as a shield against courts and developers. The whole design depended on COA actually being able to issue valid working rules. But COA's third-round rules were repeatedly challenged and struck down, and eventually the agency stopped producing binding standards altogether. Towns were left with no way to get certified, and the constitutional promise sat unenforced. In 2015, the New Jersey Supreme Court declared COA non-functional and sent primary jurisdiction back to the trial courts. COA remains the correct answer to name, precisely because its collapse is why judges now enforce Mount Laurel directly. Question 44. A developer planning a residential subdivision in the heart of the New Jersey Pinelands must first secure development approval from a state-level regional agency in addition to local municipal approvals. Which statute and agency primarily govern that overlay? Your options are A. The CAFRA statute and DEP, B. The MLO and the Planning Board, C. Pinelands Protection Act and Pinelands Commission, D. The Highlands Act and Highlands Council. What's your answer? Commit to one before I continue. The correct answer is C. Pinelands Protection Act and Pinelands Commission. C is correct because the Pinelands Protection Act of 1979 created the Pinelands Commission and the Comprehensive Management Plan that controls development inside the Pinelands area. A developer must obtain commission approval in addition to whatever municipal approvals the project requires. A is wrong because the Coastal Area Facility Review Act, known as COFRA, regulates major development in the coastal zone along the Atlantic shore. It does not govern projects inside the inland Pinelands area, which is administered under a different statutory regime. B is wrong because the Municipal Land Use Law governs ordinary local zoning, subdivision, and site plan approvals. It operates alongside, not in place of, the Pinelands Protection Act and does not provide the regional overlay required inside the Pinelands. D is wrong because the Highlands Water Protection and Planning Act addresses the Highlands region in northwest New Jersey. It applies to a separate geographic overlay administered by the Highlands Council and not to projects inside the Pinelands area. In most of New Jersey, land use control runs through the town alone, but in the state's most sensitive regions, a second layer of review sits on top of local zoning, and the Pinelands is the clearest example. Ordinary development needs local zoning, subdivision, and site plan approval from the municipality. Inside the Pinelands, that's only half the task. A project must also satisfy the Pinelands Commission's Comprehensive Management Plan, a separate and additional hurdle. The Commission's plan divides the Pinelands into management areas and matches allowed development to ecological sensitivity. A subdivision that sails through in a growth area could be forbidden outright in a preservation or forest area, letting the region protect its aquifer as a whole rather than town by town. Telling these regimes apart is mostly geography. The Coastal Area Facility Review Act covers the Atlantic coastal zone. The Municipal Land Use Law handles ordinary local approvals everywhere, and the Highlands Water Protection and Planning Act governs a separate region in the Northwest. Whenever a fact pattern places development inside the Pinelands and asks what governs, look for the state regional approval and the comprehensive plan standing behind local zoning. That's the Pinelands Protection Act and its commission at work. Question 45. A developer in Ocean County wants to fill a low-lying area of a parcel that supports cattails and standing water. The New Jersey Department of Environmental Protection generally requires permits and may regulate a vegetated buffer area around the wetland. Which statute primarily controls this oversight? Your options are A. The Freshwater Wetlands Protection Act, B. The Highlands Act, C. The Pinelands Protection Act, D. The Realty Transfer Fee Act. Pick one. Trust your gut. Here's your chance to test yourself. The correct answer is A. The Freshwater Wetlands Protection Act. A is correct because the Freshwater Wetlands Protection Act of 1987 gave New Jersey jurisdiction over wetland disturbance and required permits and transition area buffers. The DEP administers the program and reviews applications for activities that alter or fill regulated wetlands and buffer zones. B is wrong because the Highlands Water Protection and Planning Act regulates the protected Highlands region in northwest New Jersey. It does not provide the general statewide wetlands permitting regime that applies to a low-lying parcel anywhere in Ocean County. C is wrong because the Pinelands Protection Act controls development within the Pinelands geographic boundary. While many Pinelands parcels include wetlands, the statewide freshwater wetlands permits and transition area framework rest on a separate statute. D is wrong because the Realty Transfer Fee Act imposes a fee on the recording of deeds and is collected at closing. It has no environmental permitting role and is unconnected to the regulation of filling wetlands or maintaining vegetated buffers. A developer eyes a soggy, cattail-covered corner of a New Jersey parcel and figures on filling it to gain buildable ground. That instinct runs straight into the Freshwater Wetlands Protection Act of 1987, which requires a state permit before anyone fills, drains, or otherwise alters a regulated wetland. Wetlands earn this protection because they perform functions the public depends on, absorbing floodwaters, filtering pollutants before they reach groundwater, and sheltering wildlife. Once filled, they rarely come back, which is why cattails and standing water are treated as serious legal red flags, not just scenery. The law reaches further than the wet ground itself. Beyond the wetland proper, it regulates a transition area, a vegetated buffer surrounding the wetland, because disturbing land right up to the edge damages the wetland underneath it. The buffer's width isn't fixed. A wetland supporting rare species or exceptional resources carries a wider transition area than an ordinary one. Determining where the wetland actually begins is a technical exercise called delineation, based on soils, hydrology, and vegetation, so owners are wise to delineate before they build, not after they've spent the money. When a scenario describes filling a wet, cattail-covered area and the buffer around it, the controlling statute is the Freshwater Wetlands Protection Act. The lasting point is the buffer itself. The law protects not just the wetland, but a measured band of land surrounding it. Question 46. A developer wants to build a multi-story commercial project just inland from the Atlantic shoreline in Atlantic County. The project triggers a state environmental review of major development within a designated coastal zone. Which statute primarily controls the required review? Your options are A. Freshwater Wetlands Protection Act. B. Pinelands Protection Act. C. Real Estate Sales Full Disclosure Act. D. Coastal Area Facility Review Act. Which would you go with? Lock it in before the reveal. The correct answer is D. Coastal Area Facility Review Act. D is correct because the Coastal Area Facility Review Act, known as CAFRA, regulates major development in the coastal zone along New Jersey's Atlantic coast. The Department of Environmental Protection issues CAFRA permits based on project size, location, and impact under the implementing rules. A is wrong because the Freshwater Wetlands Protection Act addresses inland wetlands and transition areas across the state. It does not provide the dedicated coastal zone review framework that controls major shorefront development under CAFRA. B is wrong because the Pinelands Protection Act covers development inside the Pinelands area in south central New Jersey. It does not extend to the Atlantic shoreline in Atlantic County, which is regulated by a separate coastal statute. C is wrong because the Real Estate Sales Full Disclosure Act regulates large subdivision and out-of-state offering registrations through the New Jersey Real Estate Commission. It has no role in coastal zone environmental permits for commercial development. New Jersey gives its Atlantic shoreline a special layer of environmental review that inland projects never face. That review comes from the Coastal Area Facility Review Act, known as CAFRA, and it governs major development within a designated coastal zone. The coast carries risks and pressures found nowhere else in the state: storm surge and flooding, dunes and beaches that buffer inland areas, waters that support fisheries and tourism, and relentless demand to build there. Leaving that pressure entirely to local governments risks overdevelopment of a fragile, publicly important shoreline. The Department of Environmental Protection decides CAFRA applications based on a project's size, location, and likely impact, and a qualifying project must clear this review in addition to any local approvals. What pulls a project into CAFRA review is a combination of location and scale, whether it sits in the coastal zone, whether it crosses thresholds like dwelling units or impervious surface, and how close it is to the water, with tighter triggers near the shore. CAFRA is the coastal counterpart to the wetlands and pinelands programs. The moment a fact pattern moves to the Atlantic shoreline with a substantial project, this is the overlay that governs. Question 47. A landowner in northwestern New Jersey discovers that her parcel falls within a state-designated preservation area subject to strict limits on subdivision and impervious cover, designed to protect drinking water supply for millions of residents. Which statute most likely governs that designation? Your options are A. Coastal Area Facility Review Act, B. Freshwater Wetlands Protection Act, C. Highlands Water Protection and Planning Act, D. Farmland Assessment Act of 1964. Don't overthink it. Which one feels right? The correct answer is C. Highlands Water Protection and Planning Act. C is correct because the Highlands Water Protection and Planning Act protects the Highland region in northwestern New Jersey, the source of drinking water for many residents. The Act sets up a preservation area with strict limits on development administered by the Highlands Council. A is wrong because the Coastal Area Facility Review Act applies to the Atlantic coastal zone, not to inland watersheds in the northwestern part of the state. The Highlands designation is geographically separate and rests on a different statutory scheme. B is wrong because the Freshwater Wetlands Protection Act regulates wetlands and transition areas statewide. While a Highlands parcel may include wetlands, the broader regional preservation overlay tied to water supply is a separate program under the Highlands Act. D is wrong because the Farmland Assessment Act of 1964 grants preferential tax treatment for actively farmed land. It is a property tax statute, not a regional land use control, and does not govern subdivision limits in the Highlands. Every part of the Highlands Water Protection and Planning Act flows from one purpose: safeguarding the drinking water that millions of New Jersey residents rely on. To understand the statute, you have to start with that goal, not with the rules themselves. Rain that falls on forests and open ground soaks in, recharging aquifers and feeding reservoirs. Rain that falls on roofs, driveways, and parking lots runs off instead, carrying pollutants and reducing recharge. So paving over a watershed both dirties and shrinks the drinking water supply. The Highlands Act splits the region in two. The preservation area holds the most sensitive lands and faces mandatory, stringent controls under the regional master plan, while the surrounding planning areas treated more flexibly, with municipalities encouraged, not compelled, to conform. The core tools are limits on how many lots a parcel can be split into and caps on impervious cover, administered by the Highlands Council. These controls are deliberately severe, reflecting a judgment that protecting the water supply outweighs individual development value in the most sensitive zones. So whenever a scenario ties strict subdivision and impervious cover limits in the northwestern Highlands to protecting a regional drinking water supply, the answer is the Highlands Water Protection and Planning Act. Question 48. An owner of bayfront property in Cape May County applies for a permit to build a private dock extending over a tidal flat. Title to the underwater land may be subject to a state interest under a long-standing doctrine reserving such lands. Which interest best captures the state ownership? Your options are A. Tidelands grant interest of the state, B. A federal navigation servitude, C. A municipal special assessment lien, D. A homestead exemption. Got a guess? Lock it in! The correct answer is A. Tidelands grant interest of the state. A is correct because New Jersey holds title to lands now, or formerly flowed by tidal waters as tidelands, subject to the public trust doctrine. A dock or fill in such areas typically needs a tidelands grant or license from the state. B is wrong because a federal navigation servitude is the federal government's authority over navigable waters and the bed beneath them. It addresses federal interests, not the state ownership claim that arises under New Jersey's Tideland Statute and the public trust doctrine. C is wrong because a municipal special assessment lien funds a local improvement and is recorded against benefited property. It has nothing to do with state ownership of tidally flowed underwater land, which arises from a different historical and statutory source. D is wrong because the homestead exemption protects a portion of a primary residence from certain creditors. New Jersey has no broad homestead exemption, and even where one exists, it is irrelevant to a state ownership interest in tidal bottoms. Here's a fact that surprises many waterfront owners. The land beneath the water at the edge of a bayfront property may belong not to them, but to the state of New Jersey. This comes from the public trust doctrine, inherited from English common law. The sovereign holds tidally flowed lands in trust for public uses like navigation, commerce, and fishing. New Jersey took on that ownership at statehood. So tidal beds, even land the tide once reached but no longer does, are presumptively state property. A private owner's title typically stops at the historic high water mark. Below and beyond that line, the state owns the ground, which is why a dock crossing a tidal flat may be crossing land the owner never actually held. The state resolves these claims through specific instruments. A grant actually conveys the state's ownership interest, often for land long since filled and built upon. A lease or license permits a use like a dock without transferring ownership. This ownership question sits alongside but separate from any environmental permit the project also needs. A shorefront owner has real riparian and literal rights to use the water, but the land under the tide belongs to the state, which is why reaching out over it requires the state's permission. Question 49. A working farmer in Hunterdon County keeps at least 5 acres in active agricultural use, satisfies a statutory minimum annual income from farm products, and applies for preferential property tax treatment. Which New Jersey statute provides for that reduced tax assessment for qualifying farmland? Your options are A. The Realty Transfer Fee Act, B. The Pinelands Protection Act, C. The Highlands Act, D. The Farmland Assessment Act of 1964. Which one is it? Pause the video if you need more time. The correct answer is D. The Farmland Assessment Act of 1964. D is correct because the Farmland Assessment Act of 1964 grants preferential assessment to land in active agricultural or horticultural use that meets statutory acreage and income requirements. The reduced assessment is recaptured through a rollback tax if the use changes. A is wrong because the Realty Transfer Fee Act imposes a fee on the recording of deeds at closing. It is a revenue statute tied to transfers, not a property tax preference for active farm operations under qualifying acreage and income thresholds. B is wrong because the Pinelands Protection Act regulates development inside the Pinelands area through the Pinelands Commission. It is a land use statute rather than a property tax preference, and it does not by itself reduce assessments for active farmland. C is wrong because the Highlands Act protects the Highlands region in northwest New Jersey through development limits administered by the Highlands Council. It is a regional land use program, not a tax abatement statute, and does not turn on farm acreage thresholds. This statute rewards a landowner for keeping farmland in farming. The key to placing it correctly is understanding it as a tax incentive, not a land use control. Qualifying isn't automatic. The land must be actively devoted to agriculture or horticulture, generally on at least 5 acres, and it must produce a statutory minimum amount of farm income each year, reserving the benefit for genuine farming operations. The mechanism runs through valuation. Ordinary land is assessed at market value, inflated by development potential, but qualifying farmland is instead assessed at its lower productivity value, what the ground is worth for farming alone. The state's reasoning is economic and geographic. Taxing farmland at development value would force farmers to sell to developers just to afford the bill. This lower assessment removes that pressure and keeps farming feasible. There is a catch. If the owner takes the land out of agriculture, the statute imposes a rollback tax that recaptures the savings for a set number of recent years, preventing owners from banking low taxes and cashing out at development value. Question 50. A subdivision in Morristown is governed by recorded covenants, conditions, and restrictions that limit homes to 1 story, prohibit detached storage sheds, and require approval of paint colors. A buyer purchases a lot with notice of these restrictions. Which body usually enforces these private rules? Your options are A. The Municipal Zoning Board of Adjustment, B. The New Jersey Real Estate Commission, C. The Homeowners Association by civil action, D. The Department of Environmental Protection. Take a second. Which answer would you pick? The correct answer is C. The Homeowners Association by civil action. C is correct because recorded CC&Rs in a planned community run with the land and bind successor owners. The Homeowners Association typically enforces them through civil action, seeking injunctive relief or money damages, since these are private restrictions rather than public regulations. A is wrong because the Zoning Board of Adjustment hears applications for variances, conditional use questions, and zoning appeals under the MLUL. It enforces public zoning rules rather than private deed restrictions, which are governed by association documents and civil enforcement. B is wrong because the New Jersey Real Estate Commission regulates licensee conduct under the License Act and the rules in NJAC. ISA. It does not enforce private CC&Rs in subdivisions, which are managed by the association or another owner with standing to sue. D is wrong because the Department of Environmental Protection administers environmental statutes such as the Wetlands Act and CAFRA. It does not enforce private community restrictions on paint colors or storage sheds, which are not within its statutory mandate. Beyond zoning and government rules lies one more layer of ownership, private restrictions written into a property's own chain of title. In a recorded subdivision, covenants, conditions, and restrictions, known as CC&Rs, might limit homes to 1 story, forbid detached sheds, and even require approval of paint colors. These are private rules enforced not by the government but by the community itself. Because these restrictions are recorded, every buyer takes title with notice of them. They attach to the lot itself, not to whoever first agreed, so each new owner is bound the same as the last. Day-to-day enforcement runs through the association's own Architectural Review Committee, which approves or denies paint and shed requests under the recorded declaration. The association also collects assessments and can place a lien on a lot, with the civil lawsuit as the final backstop against a defiant owner. Public zoning and private CC and RS can both apply to the same lot, and when they conflict, the owner must satisfy whichever is stricter. Remember, the Homeowners Association enforces these private rules through civil lawsuits, not any government agency. That wraps up our question and answer review for Section 1, Property Ownership. If you'd like more questions to practice everything we just went over, head to our website. You'll find the link right down in the description below. Once you're there, you'll discover hundreds of free practice questions, plus complete study guides, all ready and waiting for you to dive into and explore. Subscribe so you don't miss the next part, and good luck on your exam.